And I'm going to call this meeting of the Planning Commission to order and establish that we have a quorum. We have 5 members, 2 absent. A quorum is 4, I believe, so we can move forward and conduct business. We usually do the pledge before we start the meeting, but we don't have a flag, John.
I think that's why we lifted off the agenda.
Okay. All right, I'm going to leave that. I'm going to skip that then. I'm going to go to the consent agenda. The commission may request for a consent agenda item to be moved to the regular agenda for presentation and public comment. Otherwise, the consent agenda will be considered in one vote. Item D on the consent agenda, Arden Estates, Section 4. The applicant has requested that be moved to the regular agenda. So it'll be the first item that we consider under the subdivision plats section. Otherwise, I guess the remaining items on the consent agenda will stay. Do I have a motion?
Make a motion to approve without D.
Okay.
Second.
We have a motion and a second to approve the consent agenda without item D. All in favor, say aye.
Aye.
Opposed? So 5-0. With the number of people here to speak on the LifePoint Church case, I'm going to take that case first. We're going to skip the subdivision plats and go down to special uses. Council has final authority for approval of special uses. SU 21-01 LifePoint Baptist Church, a review and reauthorization of a special use to allow an indoor multi-use recreational facility and related recreational activities, daycare, community outreach, community services, and educational programs on properties zoned single-family residential and 2-family residential located at 810 and 811 Austin Street and 818 Kenwood Drive.
Good morning. Shelley Pascal, City Planner. This is a review and a reauthorization of a special use to allow several different things, including indoor recreational facility, daycare, community outreach, community services, and educational program. This is located in District 5, Lane Carter, and the neighborhood is Santa Rita. As you may recall, this did go to Planning Commission in September 16, 2019, with no recommendation to City Council due to a tie vote of 2-2. City Council did approve this case of special use on September 17, 2019. The recreation facility has operated since around the end of 2019 at this facility. During that time, since open of operation, they received 1 code violation for posting signs in the right-of-way, which they promptly corrected. And there was no police activity reports or anything at this subject property. This property is located within the future land use of neighborhood, and the zoning is single-family residential and 2-family residential. Here's a couple of photos of the subject property and the surrounding areas. This is the actual gymnasium that the operation is operating from, and a residence looking across from Avenue D. A few more residents, both across Kenwood Drive. And this is a residence across Washington, residences across Washington. One more residence behind the church, and this right picture is a property of River Terrace. And we did, throughout the last year or so, we did take random photos of the subject property to see at peak times to see what was happening. And these are photographs of River Terrace. And here's a photograph of the church/gym parking lot. This was on a Wednesday night, which is one of the more peak times of the operations. Here's a few more, just kind of getting a grasp of the parking lot and the coverage of it. City staff, we believe that the impacts are minimal to the neighborhood, and it is consistent with the zoning ordinance. Special uses allow a review of uses that may be appropriate for designated areas. The proposed use, it does occupy an existing building, and the existing parking does meet parking requirements according to the zoning ordinance for both the recreational activities and the church. We believe that this is a transitional area between the core of the neighborhood and higher intensity uses on South Abe corridor. Staff, we do believe it's compatible with the surrounding area. There's no substantial increase in impact from the existing church uses. This facility is very close to a major arterial, about 2 to 3 blocks away, and it is adjacent to the River Terrace, which hosts numerous events in the area. We did review over the past year or so, indicating minimal traffic impacts throughout the day, and not continuous throughout the day, but more of not continuous throughout the day like a typical commercial activity. Most traffic comes directly from Washington, which is a major collector, rather than through the neighborhood. We do not anticipate any negative impacts on the environment. And as a community need, this special use does allow recreation and community services that we feel we need as a community. According to the development patterns, there is no change in the current development patterns. And the uses occupying the existing church building have been used for similar functions in the past, and there is all necessary parking on the site. City staff, we did send out 40 notifications. We received 2 letters in favor. We received 440 emails and 28 letters in favor for this business to operate out of that gymnasium. We did receive 29 in opposition. Of those 29, 15 were actual parcels, and then we received 17 from River Terrace. City staff, we do recommend approval of this the special use, subject to 5 conditions of approval. Any new lighting shall be shielded to minimize trespass and limit the hours of operation to 7 a.m. and 8 p.m. on weekdays and 7 to 9 on weekends. Any illuminated sign must be turned off between 11 p.m. and 6 a.m. And keep in mind, any new signage must be approved by the Design and Historic Review Commission. Any new signs must comply with the non-residential uses within the residential zoning district. And condition number 5 is that the city may inspect the property to verify compliance.
Good morning. John James, Director of Planning and Development Services. I just wanted to address a couple of things because of some of the questions and comments that have come up. I wanted to first clarify that approval of a special use is not a rezoning of the property. The underlying zoning stays the same as it is today. Special use is a unique process in the zoning ordinance that allows certain uses to be considered within existing zoning as an added additional use, and that's the process that we're going through today. The ordinance does say that the commission as well as the city council should give consideration to conditions that will minimize any negative impacts of this particular use. So what would the special use allow? That's another question that we've received. This does not open up this site for general commercial activity. There couldn't be a 7-Eleven, there couldn't be any other type of commercial. It's limited just to these specifically listed uses, including the recreational facility, daycare, community outreach, and educational programs. Just as a note, all of these would be allowed by the church if the church was operating them as part of their actual programs of the church, and so this is an additional adding the special use to allow this in this particular way. But again, as I said, this would not allow any other commercial or retail uses other than those listed. I just wanted to point out this as well. These are other special uses in the neighborhood. Over the past 55 years is the length of time our records go back. Exactly 55 special uses have been approved within this general neighborhood. Obviously averaging about one a year. That includes 8 daycares, 7 offices, 6 retail or restaurants, 6 for parking, commercial parking or storage, 3 beauty or barber shops, and then 3 other non-residential uses. So while it's not, I wouldn't call it common that commercial uses are allowed within a residential neighborhood, it's also not uncommon for these kinds of things to be considered. Again, your role is to look at these on a case-by-case basis and determine, is this particular use being requested an appropriate use for this particular site at this particular location? Again, this is the staff recommendation is for you to make a motion to recommend approval of this special use, subject to those 5 conditions of approval that Shelley had mentioned. With that, Shelley and I would be happy to answer any questions.
Anyone have questions for the staff? Can you go back to the map?
This one?
Yes. What are the red?
I'm glad you asked. I meant to point that out. The green are approved special uses or conditional uses. The red, or the light color, the pinkish color, is those that were withdrawn through the process. It did not complete the process. And the red are special uses that were denied for whatever reason.
Okay. The larger tract that's on the north end of Santa Rita Park is the school. Is that correct?
Yes.
Okay.
And that, I believe, was for some telecommunications equipment, cell tower kinds of things.
Okay.
And so there are more green on the map than what I've listed here. The list is just the ones that are some type of commercial, non-residential activity. There are some of...
Well, I would expect that a lot of the cases that we've heard where we have a single-family zoned lot and I remember a case maybe a year or so ago where we had a rezone to a 2-family from a single family within the existing structure or something. I'm assuming a lot of or several of the cases within the neighborhood are probably similar.
They are, although the one you mentioned would not be reflected on this map because I believe that was an actual rezoning.
It was a rezoning.
To the RS2 duplex district.
Okay.
So these would only be special uses that are specifically things that could be
Where the
allowed.
zoning remains.
Right, the zoning remains as is, and
Okay.
there's an additional use authorized.
Okay. Anyone else have questions? Okay. We're going to open it up for public comment. I'd like to limit the time for speakers to 6 minutes, which I'm hoping everyone seems to think is reasonable. And if you would, 6 minutes?
Wow.
Is that okay?
It's a long time. That's a long time.
5 minutes?
How about 3?
I will say 3 to 5 is typical. It's usually at the discretion of the chair.
Okay.
But we typically do either 3 minutes or 5 minutes. I'll note that
How about 5 minutes?
under our rules, the proponent, in this case, the church, would get additional, is it?
Yeah, it's a public hearing, so that
Right.
the church would need to be able to present their.
Sure.
Right, but then you would limit anyone other than those or the applicant themselves to the 3 or 5 minutes.
Okay, so let's do 5 minutes. Yes, sir, Mr. Wardle.
Chairman,
Yes, sir.
Point of order here. I think most people can complete their presentation within that time frame. However, I think there may be 1 or 2 of us that can't. And the reason is this is an unusual hearing, as you know.
Yes, sir.
We got the 2019 hearings, which is supposed to be reauthorized here. Then we got today's hearing. Then we've got to address the thing out on A&M Street.
Yes, sir.
And superimposed upon all 3 of those, we've got litigation that we need to
How is
address
A&M Street
briefly.
a part of this today?
It's not part
It's
of
not a
this
part of
case.
this.
Separate case.
Okay.
No.
So we're not discussing A&M today?
No, it's a separate case,
Yeah.
separate hearing.
Comments should be limited only to this case.
Correct.
Anything else would be a violation of the Open Meetings Act, if it's not on the agenda, so.
Correct.
It's entirely at the discretion of the chair. We typically would, if we limit speakers, we would limit all speakers,
Okay.
except the proponent.
So I guess the issue I have here is that Mr. Wardlaw, it appears, has done a lot of legwork on this case and probably represents the overwhelming majority of the folks that would oppose the case. So
That's correct, Mr. Chairman.
would there be a problem with allowing Mr. Wardlaw 8 or 10 minutes to get through it? I'm assuming that would probably help reduce the time that some of the other folks
I
speak.
think it's at your discretion, Mr. Chairman.
Okay.
If you do that, Travis, are you going to remove some of those other names that are on there to speak?
I don't think I can keep people from speaking, but I don't
No, I
think
think-
that the people that are going to speak are going to take 5 minutes
Okay.
to speak.
And one other thing, Mr. Chairman, this is kind of a 3-on-1 proposition.
Okay.
You got the city staff, you got the church, and you got the Texas Tumbleweeds. All three of those are aligned against the neighborhood. So, you know, if everybody had the same amount of time, in theory, they would be getting 3 times as much press as we get. So,
Okay.
I think the proponent has a representative who plans to do their presentation.
Sure.
So, I mean, I guess anyone else that wants to speak in favor should still be limited to the 3 to 5 minutes or whatever you're deciding.
Exactly.
But the one representative could be allowed.
Okay. Would 10 minutes suffice for your presentation, Mr. Wardlaw?
yes, I believe so.
Okay.
I would appreciate that.
Okay. Thank you, sir. So we've opened it up for public comment. If you wish to speak on this case, if you would please state your name and your address or single member district or something that tells us where you're coming from before you speak. I would appreciate it.
Good morning, Planning Commissioners. My name is Dustin Gaines, and I am the attorney representing LifePoint Baptist Church and Texas Tumbleweeds Gymnastics. Thank you for your time today. I wanted to start off today by just providing a little bit of background on this case for purposes of the Planning Commissioners' understanding and then also for the future meetings that we may have. The background of this case, back in 2019, the church had its gymnasium that was not being used all that often. It was being used for certain church activities and recreational needs. And the church leadership, the church is led by its pastor, Jay Clatworthy, and it has deacons. It's an independent church. It's not a part of a hierarchical denomination. Everything is governed and controlled independently within the congregation. The deacons, they said, we want to have a way to be able to use our gymnasium. We want to be able to use that to be able to serve the community. We want to be able to reach young people. We want to be able to help. And at the same time, Texas Tumbleweeds Gymnastics, it was looking for a place to be able to operate its gymnastics academy. And Texas Tumbleweeds, its motto is to do all to the glory of God. And it was looking for a place where it would be able to take teaching gymnastics and to be able to present that through a biblical Christian worldview. And it was a perfect match. Pastor and the deacons and Landon Knight, the owner of Texas Tumbleweeds, they were able to get together and they entered into an agreement, and part of that agreement was memorialized in a memorandum of understanding. And I just wanted to read to Planning Commission just a few portions of the memorandum of understanding here today. It says, whereas LBC, LifePoint Baptist Church, and Texas Tumbleweeds Gymnastics, or TTG, desire to enter into an agreement which LBC and TTG will work together to promote the gospel. And whereas LBC and TTG are desirous to enter into a memorandum of understanding between them, setting out the working arrangements that each of the partners agree are necessary to promote the gospel. Services rendered later on in the memorandum by LBC to maintain as first importance the pursuit of the glory of Christ in all things. Number 2, to offer literature to the participants of Texas Tumbleweeds gymnastics programs that aim at evangelism and spiritual formation. Offer spiritual care and counsel to any member of the Texas Tumbleweeds gymnastics community. Offer spiritual oversight and guidance to the mission and work of Texas Tumbleweeds gymnastics. Promote the mission of LifePoint Baptist Church at Texas Tumbleweed gymnastics activities when requested. Those were the services and the part of LifePoint Baptist to Texas Tumbleweed. Texas Tumbleweed's responsibilities are to maintain as first importance the pursuit of the glory of Christ in all things. Allow LBC to promote the gospel by disseminating literature provided by the church. Have regular devotions with all participants of Texas Tumbleweeds gymnastics. These devotions will be evangelistic and spiritually formative, conduct activities in accordance with and not contrary to the statement of faith of LifePoint Baptist Church. And now for over a year, Texas Tumbleweeds has been operating, and students are able to go into the gym, and every day the students have devotions, they have prayer. Pastor of LifePoint has been able to go over to the gym and be able to minister to families, be able to provide church literature, to be able to use and have Texas Tumbleweeds and the families that are there as an outreach opportunity and be available to help for care and counsel in any way. And the reason that I mention these things here to Planning Commission here today is from the very beginning, LifePoint's Baptist deacons and pastor were seeking a way to use that gymnasium to minister to the people of San Angelo. And they've been able to do that throughout this past year. There have been no noise complaints. There have been no violations. The only complaint was the misplacement inadvertently of a sign, which was promptly corrected. The traffic has been minimal, and just over the last several days, we've received this many emails in support from the citizens of San Angelo regarding the use of the gymnasium. And these are all the emails that have come in that were referenced a little earlier. And I wanted to just bring to Planning Commission's attention the Religious Land Use and Institutionalized Persons Act. It's federal legislation. Oddly, it's for inmates and for religious land use. And it governs the ability of churches to be able to use their land in accordance with their belief and with their statement of faith. Under 300 feet away, the River Terrace owns and operates a restaurant, and at that restaurant, it's RS1, and it operates that restaurant under a special use permit. Under the RLUIPA equal terms provision, a city planning commission or city council cannot treat a religious entity on less than equal terms with a similarly situated secular entity. And just under 300 feet away, you have the exact same zoning scheme and the exact same special use permit that is being allowed for a secular purpose. Texas Tumbleweeds, prior to moving to the church, it operated and it even sought rezoning for its old location. And it was given that rezoning. And then here today, we have the minute that Texas Tumbleweeds joined in and partnered with the church and opened to become more faith-based, there's opposition and a threat of it being shut down and not allowed to be able to do that. So for those reasons, we would respectfully request and we would thank Planning Commission for its time and consideration today. And we're looking forward to a favorable decision and would be available for any questions that Planning Commission may have. Thank you.
Thank you, Dustin.
Good morning, and thank you for your time. My name is Dave. I live in the 1600 block of South Monroe, longtime Santa Rita resident. And I'm sorry that we all have to be here for this foolishness because we're just talking about kids. We're not talking about a chapter house for the Sons of Anarchy, okay? It's just a bunch of people in their minivans dropping their kids off for gymnastics. And the fact that this gentleman wants to enrich himself shame on you. That is just simply shameful that anybody would seek to enrich themselves over this situation. Now, I told you I live on South Monroe, which is important because it's this far from Santa Rita Elementary. A lot of traffic and to school, okay? It happens. This gentleman chose to live just off of Washington. Do you have any idea how busy Washington is? I'm sure y'all have done your due diligence. You know that that is an amazingly busy street. And this many more people are coming in. And he wants money. He chose to live there. It's Washington. You knew it going in. Okay? I live on Monroe. I know what it's like. No mystery here. And again, shame on you. Thank you.
Okay, thank you, sir.
Mr. Chairman, may I clarify the record?
Yes, sir.
I'm operating pro bono in this case. I have never charged the city of Santa Rita a single dime in 35 years of representing the neighborhood. So I don't know what he's talking about.
Yes, sir. Thank you.
I'm losing money.
I would also appreciate for those doing public comment going forward to direct your comments at the Planning Commission and not to the members of the crowd, please.
Good morning, Commissioners. I'm Ann West. Thank you for allowing us to speak this morning. We appreciate and realize that there are times that you must make tough decisions serving on this board. The LifePoint Baptist Church requests to make all of their property zoned commercial, we feel should not be allowed, and we hope that it will not become commercially zoned. The neighborhood that surrounds that area is over 100 years old, and my family alone, 4 generations have lived in that neighborhood. That history belongs to a lot of families. The homeowners who have purchased their homes in that area, past and present, have done so never dreaming that they would be faced with any type of commercial retail businesses entering that neighborhood. As our mayor, Brenda Gunner, recently said at another zoning case in our district nearby on A&M Street, one's home is their biggest asset. Another council person, Mrs. Billy DeWitt, made a comment. She stated, once a zone change goes in, the city has no control what goes in later, and this is a big problem in our town already. Our own council representative, Lane Carter, spoke passionately about not integrating any type of commercial business into a residential neighborhood. All we're asking for is the same representation, the same protection, and the same consideration afforded all the other neighborhoods in this city. We have enjoyed a friendly, neighborly relationship with churches in this location for many, many years without conflict. They were always able to meet their community outreach, their community service, and their educational obligations without rezoning or bringing in any type of retail businesses. The issue, in our opinion, has never been about the gymnastics, Texas tumbleweeds, the children, the church. It's always been about changing a residential neighborhood to a commercial entity. The churches in the past have relocated from that neighborhood and that location. And it's possible that this church will locate as well, or possibly sell part of that property. The zone change that goes with the church, the zone change does not go with the church if they leave. It always stays with the property, as you know. And that can be a huge problem. We don't have the built-in protections that other neighborhoods have through deed restrictions in Santa Rita. The current zoning ordinance is our only protection in this neighborhood, and we feel like it must remain in place. So today we are asking for your consideration and your assistance in this matter, and hoping that you will help us protect this neighborhood. Thank you.
Thank you.
Do we need to reiterate it is not a zone change?
Yes.
It is not a commercial
Yeah,
zone change?
is it appropriate for us to clarify some of the
Yes.
Yes.
comments
Sure,
in there?
sure. I don't think it hurts.
I mean, And I'd be open to, John or Brandon, if you guys want to comment on, the discussion of zone change versus special use, the limitations that can be placed within that special use request. I think that would maybe help clarify.
Right, as I mentioned earlier, that this is not a rezoning, it's not allowing open-ended commercial uses. Your approval is specific to the uses requested, and you can place, as you noted, the recommended list of conditions, you can place whatever conditions you choose on a special use, and so it is not a broad, open-ended rezoning. It is as limited as you want it to be.
Okay. Thank you. Yes, sir.
My name is Phil McCormick. I'm a real estate appraiser. Excuse me, I don't live here, but I have had an office in San Angelo since 1976, appraising real estate. Back in all the way through the 80s, I had 5 appraisers working for me, and we probably appraised 80 or 90% of the houses in San Angelo. Santa Rita has always been the premier residential neighborhood that people wanted to live in, that they wanted to raise their family in, that kind of thing. And let me just tell you, from a neighborhood standpoint, which is a grouping of homogeneous buildings, residences, whatever, Santa Rita has always fit that delineation that we have. To allow changes in a neighborhood often indicates, not only to the people there, but to the general public, that there's a change going on in that neighborhood and that it's deteriorating or making some kind of change. And so I'm simply here to tell you that if you want to maintain property values and maintain uses, that you need to really treat changes in those uses, particularly in a neighborhood like Santa Rita, very tenderly. Because once you open that door, and I understand about the special use deal, but once you grant a special use here, then what's going to keep you from granting that special use the next time and the next time? And then eventually there's going to be a commercial change. I just think it's something y'all need to take under great consideration. Even though I don't live in Santa Rita, I don't have a dog in this hunt. I'm simply telling you what I've seen over 46 years of appraising real estate around here.
Thank you, sir.
Thank you.
Thank you.
Good morning, Commissioners. Heidi Brooks. I am a Santa Rita resident and a former Planning and Zoning Commissioner. I'd like to begin by stating that this hearing is a do-over. We wouldn't be here today if it weren't for a lawsuit set to be heard next month. When first heard, the city informed half of the property owners within the 200-foot zone of the rezone change, as well as a case going before the council in less than 24 hours after the Planning and Zoning meeting, with only one reading for its approval. That was wrong and is wrong. This time, the city is calling this a special use permit. They're trying to make us believe there would be only special use. This area was platted 100 years ago as a residential neighborhood. We want to keep it that way. You'll hear from people today sharing their emotions. They will more than likely tell you that they love how safe they are, that this area feels safe, that their kids are safe, and that they like it here. This case has nothing to do with feelings. It is about right and wrong. Since Tumbleweeds moved in and LifePoint became a commercial business, they have paid no taxes. Their nonprofit status should have been terminated the minute they went into business on the church property. They can be in business and operate a gymnastic facility, make money, pay taxes on that income, and still be a nonprofit church. They do not have the right to use the property to run a business and not pay taxes. There may be need for more recreational activity centers in San Angelo. There is commercial property all over this city that is empty. In fact, after Tumbleweeds moved to the church property, some of its instructors left and opened Rise Gym in Sunset Mall, which is commercially zoned. And they have a waiting list for their classes. Everyone needs to be completely transparent about what is really happening here. I've passed you out a petition signed by 185 neighbors that are not in favor of this zone change. I'm asking that you please keep our voices in mind as you consider this case. Thank you.
Thank you.
Just to let the commission know, we will need to borrow one of those sets so that staff has a copy for the record.
Yes, sir.
Mr. Chairman, before I start, may I hand out to the members of the commission a document I'd like to send to read, follow along.
Thank you, sir.
Thank you.
Okay, for the record, my name is H.R. Wardlaw III. I've been a resident of Santa Rita for some 70-plus years, and I've been an attorney around here for at least 50 years, for better or worse. I also have been on the city council several times, so I've donated some community service, just like you folks have, at no cost, no money, and thankless, no thanks, which y'all can understand completely. I didn't know I was evil for not charging anything, probably a reflection on my intelligence, but I just inherited the protectorship of the Santa Rita since I lived there all my life, and these are great people. And so this thing all started back in August of 2019, and that's when the church approached the city to be able to place commercial ventures on the church property. And at the time, they told the city and everybody that they had Texas Tumbleweeds waiting in the wings, and they had a deal with them for the gymnasium over there. But they stated, and it got it passed, that the entire church property is now zoned for commercial use, and that is a block and one half, a city block and a half, which encompasses 15 lots. So, they said the reason for that was they were going to get other businesses to move in there too, and they needed the money because their congregation had shrunk substantially. Well, of course, now that we filed a lawsuit after this resolution passed back in September the 17th of 2019, there obviously haven't been any more commercial businesses alight in this area because this lawsuit is hanging over their head. And this lawsuit, by the way, is set for hearing on June the 15th, just a few days from now. We want our day in court, and we're entitled to that. And if you will look at this resolution, which is what passed back in, this is what started all this, and this is a special use permit that was generated by this resolution. Well, if you'll look down there where I've highlighted, it shows a permanent, now therefore be it resolved by the City of San Angelo, Texas, that a permanent special use is approved. So nearly all of these zone changes or zoning amendments they're permanent. They're in perpetuity, and they run with the land. They don't go with the church if they move. It's in perpetuity. So it raises the immediate question, why are they trying to reauthorize something that's already on the records in perpetuity? Well, the answer to that is this thing that we're reauthorizing is void. It is void as it can be. And the city's lawyers, new lawyers that they hired, know that. And everybody knows it. They did not give notice. You people know that when you have a zone change, you have to give everybody within 200 feet mail notice. Well, guess how many they didn't give mail notice? They did not mail notice to 15. It just missed 15. And then on the 16th, they mailed notice to poor old Judd Gray at the River Terrace, but they sent it to the wrong address. They sent it to P.O. Box 71 when his P.O. Box is 30-some-8, and so he never got it. So the cases I'll tell you, and I provided you with Peters versus Go. Once you don't follow the prescribed procedures in zoning, then it's void from that point on. And for example, what the cases say is when you fail to follow the prescribed procedures, then it's jurisdictional. And so when they didn't notify all these people, you folks had no jurisdiction to even hear the case. And then, of course, when it got to the city council, they had no jurisdiction. And these lawyers that they hired, these new lawyers, they know that. They know it for certain. It wouldn't take 5 minutes on a Nexus Lexus to find that. No notice what happens. So anyway, what we're seeing is they're trying to head off the hearing of our lawsuit on June the 15th by saying, oh, well, we might have made a mistake or two on this, even though we fought this for 2 years. But, Judge, we don't want you to give these people, the citizens of Santa Rita, any relief because we've come back in here with this reauthorization. And in this reauthorization, we have taken care of all of the defects that we did to begin with, so don't hold all this against us. So that's what's going on, and you can like that or you don't like it. Some would say it's just good lawyering, but I don't think it's the best way to treat citizens in Santa Rita or anywhere in San Angelo. We pay these people salary. So let's move on quickly to the case out there on A&M, South A&M Street, which y'all are familiar with and just came up. For a water bottling plant. And the water bottling plant, according to the testimony I remember, was it'd be about 5 or 6 cars a day.
Yeah, point of order real quick.
Point of order, we're not, this is not on our case today.
It's not part of anything today.
Oh, we can mention that. We're not asking to take any action.
Yeah, but
We don't need
you're
discussion
including
on
it, yeah. We can't have any discussion
Why
on something.
couldn't he speak about it? I don't understand.
Yeah,
why he
It
couldn't
has
speak.
nothing to do with this case.
Brendan, is that not a violation of
He's
open
in public,
meetings?
he's in public comment.
No, we're not
guys.
asking for any action to be taken. We can just talk about it. We can
Yeah.
talk about the weather. He's talking
Not
about
from what they
religion.
said.
I don't believe we're allowed to even
Other
discuss
lawyers
it.
talking about religion.
So I guess to the extent that we're talking about special uses in the area and how we're comparing this case maybe to another special use like River Terrace, I think discussion would be appropriate in that case, but I mean, yeah, we shouldn't be considering any action other than.
So
this.
let's clarify, Mr. Wardlaw. You are referring to this case for what reason? As an indication of what's been done in the past, or
No, Mr. Chairman, what I'm referring to is that the city council took this action that we all know about, where they turned down the insertion of this commercial establishment in that residential neighborhood. And it looks to me like they've established a new policy.
Okay.
In San Angelo. That's my point.
Yes, sir.
And a new precedent. And my larger point is, why would the people over in Santa Rita not be entitled to the same protection that those people over there have in that location? Whole lot less traffic out there on A&M Street. And interestingly enough, at the A&M hearing in front of the city council, the neighborhood people didn't even appear. And they didn't have a lawyer. And the city council just definitively said, we don't want any more commercial establishments inserted into a residential neighborhood. And those people, if you ever saw what they said at the city council meeting, they gave, 5 of those 6 people gave detailed explanations as to why you can't put commercial establishments in a residential neighborhood, and they voted it down. And I think that, I know those people have been all over the map, and they've driven you all crazy. I'm glad you're still sane, maybe. But it looks to me like there's a new policy. And that policy just follows the law. It follows the law in Texas. It follows the law in the United States. And I provided you the other day a copy of these deed restrictions and all of these subdivisions around town, the late newer ones. They all prohibit this. You couldn't do this in, Mr. Spano, they couldn't do this in your district out there in the Bluffs, because you saw the restriction. So the point on that is, let's have Santa Rita have the same protections that everybody else has, and I think that's what the city council is getting back into, is that kind of thing. So that's about, one other thing. The city staff is off track, just like they were when they didn't give 15 or 16 notices the last time. The law in Texas is, and there's a case called Texarkana versus Howard, and what it points out is, when you look at these zoning cases, and you're talking about a change of circumstances or commercial businesses being inserted, the case says, and a number of other cases say this too, is you only look at what's happened after the latest comprehensive land use plan. And I happened to be on the city council at that time in 2002, but anyway, you don't look at anything prior to that time. So all of these lists of old things that happened, the River Terrace was established in 1960, and that restaurant's been going on and off since then. You don't consider that. What they're trying to tell you to do is just wrong. Because see, when you have the comprehensive land use plan in 2002, then it grandfathers everything else prior to that time. And so you have to be careful about that. And I don't think there's been anything since then. And I didn't look at that map too close, but I submit to you that most of that stuff they showed you was on 2 state highways. Bryant Thruway and Beauregard and Sherwood Way. And that's a different situation.
Thank you, Mr. Wardlaw.
Thank you.
Good morning. My name is Sarah Rook. I live at 233 Burlington Road. I'm one of those that will be speaking with my emotions, I guess. So, as many of you know, and anyone who has children knows, that their worlds were turned upside down in 2020, and they were kicked out of school, out of their activities. Families weren't able to see each other. And finally, they're able to get back into the gym, and they are thriving. We are not asking for a rezoning, just a special use permit. I do have a question. I think it's for you, Mr. James. If we get a special use permit, is that just for Texas tumbleweeds? Or would that special use permit be for the land? So if eventually it moved, is that how it works?
As Mr. Wardlaw mentioned, the special use is for the property.
Okay,
And
well.
so recreational uses would be
Okay.
allowed on this property.
Well, that's what I was wondering, because, I mean, we plan to be there as long as possible, but it's not, we're not popping up a Burger King, or, you know, a Dollar General. We are also very cautious when driving around. We all have children. We all know that we need to be careful, and it's a neighborhood. We're careful driving through. No one's speeding around. I can't say no one. The parents are not speeding around. There's plenty of parking. As it's been said before, this is something that could be used by the church if it were just church-owned. They could open up a homeless shelter. How would that have an effect on property values? And that would be part of the church. So I just don't see how a gymnastics center is a problem. There's not noise complaints, there's not excess traffic, it's not like it's going late into the evenings, it's not obnoxiously early, not even really early in that matter. I guess everything's just, this is what I have to say. Our children are thriving, finally being able to be back in the gym with their friends and enjoying life again. They're resilient, but it's nice to have them back to normal. I think that's all I have to say. Thank you.
Thank you, Sarah. Thank you, Mr. Ricky.
Thank you.
Just one thing, one question I have is that after the special use was passed in 2019, there was a directive at the bottom of the resolution to change the zoning map to reflect the special use. What was it changed to?
As you saw on the map that we showed, we map not only zoning districts, we map special uses, conditional uses, and all of those kinds of things are shown on the map. So even though this, for example, is not a rezoning or a changing of the underlying zoning, that is reflected on our official map.
It applied to those 3 lots that are shaded? Why aren't all 15 lots shaded?
I guess I'm not sure the question, but everything you see on that map in red is the church-owned property that this particular special use is applicable to.
Okay, oh, I see, that's a, excuse me, I see now, that is a
Sir?
photograph.
Could you state your name into the record?
I'm sorry,
to
my
get it.
name is Lawrence Ritchie.
Thank you.
Not sure what property number we are, but my wife and I live directly across the street from the gym. And like to state, we're all for business development. We need jobs and growth in San Angelo, but all that can be achieved without destroying neighborhoods in the process. Some San Angeloans believe that the philosophy that any business, anytime, anywhere, at any cost is good for San Angelo, but most of us, even those of us in business, would say not in neighborhoods. We want a safe, peaceful place for ourselves, our children, and our families, a place to go home to after the workday ends. Neighborhoods all over San Angelo feel that they have lost their voices. However, recently, the City Council heard the neighborhood voices when it turned down the commercial zoning for a water bottling facility in College Hills. While that location was cheaper for the proponent who owned the business, it would have taken those profits out of the pockets of the surrounding homeowners by lowering the value of their homes and destroying the safe, quiet place where they live. Allowing commercial zoning in neighborhoods is a philosophy taken to an extreme and is destructive to our homes, our neighborhoods, and to our city as a whole. I gave you a comparison of this, the 7 topics that are important in considering zone changes and special use permits, and they're very similar. I don't know if you'll allow me to talk to you about that. But you can see in that comparison, is this a compatible use? The first one, is this use compatible with the comprehensive land use plan? LifePoint Church, no. This is the staff recommendation. A&M Street, no. Is this use compatible with the zoning ordinance? LifePoint, no. A&M, no. Is this use compatible with the surrounding area? LifePoint, no. A&M, no. Have conditions changed that require a zoning change in this location? No to both. Will this use have a negative impact on the environment? No to both. Is there a community need for this use in this location? No. Is this use consistent with the area's development patterns? LifePoint, yes. I don't see that there's a development pattern in Santa Rita neighborhood to allow for special use permits allowing businesses to operate.
Thank you, Mr. Rickey.
Good morning. My name's Don Payne. I'm a resident of the neighborhood. In fact, my house is directly across the street from the gymnasium at LifePoint Baptist Church. I bought my house 30 years ago this year, and before I did, I spoke with people at the church, which was then Park Heights Baptist Church. I looked into what was going on over there because I wanted to know what was happening in the neighborhood as far as traffic patterns, that sort of thing. Was I going to be able to enjoy in peace my new home? I made my decision to buy the home because I felt like the neighborhood was a neighborhood and it was a residential neighborhood and not a commercial neighborhood. There was no commercial activity going on at that time. There was the restaurant across the street at the River Club, and back then it was a club. You had to be a member of the club to be able to use the restaurant. And this was something that restaurant was created to serve the people in that residential condo, the residential high-rise, and their guests. And it was a private club for many years, and it branched out later on, and yes, the city council did approve that. The use for that was approved, but that in no way has ever altered the residential character of that building or the neighborhood. Now, to clarify a few things here, Lena, the city says that these uses that would be specifically subject to your approval. But let's look at these uses. Recreational activities, that's a pretty broad umbrella. Daycare, how many daycares? What kind of daycare? Children, adult daycare, doggy daycare? What are we looking at? Community outreach, that's a pretty broad umbrella. Community services, another broad umbrella. Educational programs, another broad umbrella. What this amounts to, it's not just about the gymnastics operation that's gone in there. Approval of this special use permit amounts to advance blind approval of an omnibus special use permit that we'll have from now on. Because no matter what staff says here, that these are subject to specific approval, these categories are not specific. And besides that, the fact is that whether they're subject to specific, even though they're not subject to specific approval, which we just talked about, the fact is, when you look at this overall scheme, if you approve special uses, particularly blind special uses like this that you don't know anything about, then what's happened is you've changed the character of the neighborhood. You've changed the zoning of the neighborhood. No matter if you call it a special use or not, you have effectively rezoned the neighborhood. And every time one of those special uses, one of those pre-approved special uses comes up, you're rezoning again, because now there's a new use in the neighborhood. City Council, at the April 20th meeting about the A&M situation, everybody who spoke, every council person who spoke at that time affirmed and passionately affirmed their commitment to neighborhoods in San Angelo, their commitment to that the city should respect the neighborhoods in San Angelo, that in fact Mayor Gunner is on record as saying, if we allow commercial development in residential neighborhoods, we start to deteriorate what we traditionally call neighborhoods. People choose a home, often their major asset, relying on the residential, not the commercial character of the neighborhood. She indicated that. She recognizes that people don't look for homes in a neighborhood where a commercial business is located. And the implication here is that residents have a right to expect and rely on the city's respect and protection of their property rights in the neighborhoods where they've chosen to buy a home, and when they bought that home, it was in reliance on the current zoning scheme that existed. And that's what's happened in this neighborhood. That's what I did. I relied on that. And all the residents of that neighborhood have relied over all these years on the fidelity of the church, the various churches that have been in that location, to the idea that this is a residential neighborhood. The church, when it first came there, when that church was first built, it built in a residential neighborhood. And they knew that it was zoned residential. And they've lived with that all these years, but now it's different. Now, the church needs to raise some money, I understand that, and so this is not a purely altruistic thing. They're trying to raise money by attracting commercial enterprises to pay them to lease space and to run businesses on their property. So let's call that what it is. This is not simply some sort of church-based community outreach. This is actually businesses that come in with a profit motive, and the church has a profit motive, and that's okay. But let's call it what it is.
Thank you, Mr. Payne. Time's expired.
Thank you.
Morning. My name is Nick Negovich. I live at 3310 Cumberland Drive. And before I get to what I was going to read, I think there's a big distinction between a bottling plant and a gymnastics facility. Bottling plant, a commercial plant, is going to have delivery trucks bringing in their own supplies, as well as taking the bottles out. It's repeatedly transferring their product. This is different. So just want to make that clarification. My wife couldn't be here today, so she asked me to come here and read this on her behalf. Last night, I asked my friends who live in Santa Rita to lend their support to our gym. I was overwhelmed by their outpouring of love and support for the children of our community. But again and again, I was asked why anyone would want to fight the gym in the first place. They couldn't understand why anyone would rather have an empty, unkept building in their neighborhood than a small children's gym. Repeatedly, I was asked why, and I didn't have an answer. Between thanking my friends and trying to explain why I had no explanation, I spent time comforting my daughter who doesn't understand why this is happening. My little girl, our little girl, who is only 9 years old and lives for her time spent learning and growing at Texas Tumbleweeds, is terrified that a place she loves so much is going to be taken from her. I tried to ease her fears. I promised her that the grown-ups would take care of this. I gave her a hug and attempted to make sense of why I had to wipe away tears from my child because someone is trying to shut down a place that brings her so much joy. Despite so many people asking me why, I still don't have an answer. What is it about a gym that bothers them so much that the other places in Santa Rita that have a special use permit? Why is a place for children to play and grow such an unwanted addition to their neighborhood? Why would they rather have an empty building than a thriving business? And why do they hate it so much that they would spread fear and lies about what is really taking place? Part of me wishes I could understand, but most of me is glad that I can't. I'm glad that I can't comprehend that much hate and loathing. And I'm proud that Texas Tumbleweeds and LifePoint have chosen to focus on spreading joy and love instead. I'm thankful that my daughter can be a part of a program that teaches her she can be strong and strive to win, while at the same time showing love for the people she's competing against. It's a relief that despite all of the ugliness being slung in our faith-centered children's gym, we haven't lost sight of why we're here. I may never understand why a small group of people are so angry and why their hearts are so full of hate. But instead of focusing on them, I'm choosing to focus my heart on making sure my daughter always chooses love and joy. I respectfully ask you to help us continue our mission by approving our special use permit. Thank you.
Thank you, Nick.
Good morning. My name's Tina Bean. I live at 520 South Washington. I'd like to first say that we aren't full of hate. We're not upset and angry. We want Texas Tumbleweeds to succeed. And we want the children to succeed. This is not about Texas Tumbleweeds. This is about, or about the opportunity for them to have a gym. In fact, there is a gym there that has been used. Our opposition and our concern is about the zoning. And what happens, Texas Tumbleweeds may not always be there, but this permit will be, and it can turn into zoning. And another concern that we have, we would like for LifePoint to succeed also, but it's concerning to us that they are not paying property taxes, and they haven't since this rezoning. If it changes to a commercial, we can't go back. You know, there's a precedence is set. But we do want Texas Tumbleweeds to succeed. Thank you.
Thank you, Ms. Bean.
Again, it's not a rezoning.
Hi, my name is Melissa Bruns. I live at 813 Windermere Circle. I have a letter to read also, but I want to say that the Rise Gymnastics and our other gym coaches leaving happened prior to this, so it doesn't matter. And it's also been thoroughly, completely debunked that we're rezoning. We're not rezoning, we're special using. Let's quit going in circles. That's ridiculous. And then I'll read my letter. I also brought, I didn't know we were bringing handouts, or I would have brought lots more handouts, but I wanted to show you guys a picture, lots of pictures of my daughter. She goes to Texas Tumbleweeds. She's gone to Texas Tumbleweeds for about 5 years now. I don't like public speaking. If I cry, that's what it is. I want to point out her foot here. Terry knows about her foot. She's gone to church with my parents for a while. She got hurt in the gymnastics gym that we had before. She specifically got hurt in the parking lot. It was a devastating injury for my daughter. Her foot was degloved. And the reason her foot was degloved was because the parking lot was terribly inadequate, completely dangerous. You were going directly into a one-way with no way to see out. And so the biggest thing about me as far as safety concerns is that my daughter will be safe. There's no through traffic right there where they're picking up and dropping off. There's no way for her to step out into traffic and get injured in the same way. And that is a huge, huge thing for me. And I'll read my letter now. My name is Melissa Bruns. My daughter has been attending Texas Tumbleweeds Gymnastics since she was 5. She has been on Team TTG for approximately 4 years. When she first started the gym, she was injured in the parking lot. A car was going too fast into a dead-end parking lot that was poorly designed. My child ran out into the parking lot, and the driver was unable to see her. The driver ran over her, and she sustained a pretty major injury to her foot that required a skin graft. It was a devastating injury that could have been prevented. I don't know if anyone else was hurt in that parking lot, but I can tell you based on the old set set up that it was very dangerous and very difficult for drivers to see potential dangers. The driveway in this new gym is laid out so much better. There is no traffic directly in front of the entryway. I feel safe knowing that when I pick up my daughter and I drop her off, that there will be no safety concerns. In addition to the better laid out parking lot, the new gym also provides a larger space so that the girls are not so cramped during their workout time. There's also ample viewing for spectators that we did not have in the other gym. So in summation, the new gym provides us much safer, more spacious area for the athletes of Texas Tumbleweeds to perfect their craft. There's a greatly reduced chance of accidents in the parking lot, which is a major improvement. I'm happy to send my daughter to the new location so she can continue to work hard and improve her skills. And that was my letter. Also, the A&M location, that doesn't have anything to do with this. It's completely different. A manufacturing facility versus something that has no economic impact. That's why that was turned down and why this one should not be. So those are not related in any capacity. I surely hope that those residents don't have hate, and I hope that they don't. This building is existing. It's already there. We're using it for a similar purpose. While we are not a church, those taxes have nothing to do with this issue either. The issue that they have is the rezoning, and we are not rezoning, and that's the issue.
Thank you. Yes, sir.
Mr. Chairman, as the proponent, may we have just 2 minutes for rebuttal?
Rebuttal on what, sir?
On the public comments that have been stated.
Okay, sure. I'll give you 2 minutes.
I just wanted to address quickly 3 issues. As the Planning Commission knows, under the special use permit factors in the ordinances, the factors that the city has outlined as far as noise, traffic, the purpose behind the special use that is being granted, no evidence today has been presented to contravene any of the city's findings as it presented today. We haven't heard any evidence of there being extreme traffic, extreme noise, or any reason to defer or to go away from what the city's recommendation was. Secondly, as it pertains to taxation, LifePoint Baptist is a nonprofit organization, and nonprofits per the Texas Property Code are exempt from property taxes. And nonprofit organizations are allowed to have what is called unrelated business income per the IRS's rules without violating any of the obligations or any of the purposes that they are accomplishing as a nonprofit or as a church. The lease that is obtained, it pales in comparison to what the market value would be. And per the agreement with the Texas Tumbleweeds on this, all of the money that has been received, it goes right into capital improvements, which should be a good thing for the community, to be able to get the gym repaired, to be able to make sure that everything is well maintained. And then thirdly, the religious use is of extreme importance because as the Planning Commission today, you're deciding to grant or deny a special use permit for a nonprofit religious entity. The bottling plant that we were hearing about today was not a religious organization. RLUIPA does not apply to that as it does to this case. And for those reasons, and for everything that has been mentioned here today, we would respectfully request that Planning Commission make a recommendation that this special use permit is approved. Thank you.
Okay. Is there anyone else that would wish to speak on this case? If so, please come forward.
Anna Wardlaw, 1201 South Park. I'm in the neighborhood. To the parents here for Texas Tumbleweeds, I want to give you a message that I think it's very important that you know. As a courtesy, a letter, a handwritten letter, was given to Texas Tumbleweeds in advance, letting them know that there was a probable lawsuit. Texas Tumbleweeds chose to move knowing that they had advanced warning. And I believe there was like 90 days or so between the time that the letter was delivered and the time that they moved in.
Thank you, Ms. Wardlaw. All right, is there anyone else wishing to speak on this case? If so, please come forward. right. I'm going to close public comment, open it up for discussion amongst the Planning Commission members. Mr. Yerk, do you have any thoughts that you'd like to share?
Yeah, just trying to make sure my mic's on. So I think, something that's worth discussing, that's been discussed, that continues to be an issue, that needs to be addressed is the notification process. I think that's probably at the crux of the, conflict for the most part, where people don't feel like they're given adequate time to respond to potential changes to something that's going to affect their property that they own. And I feel like it's so important that we bring that up. And I think there's some steps being taken to hopefully remedy that going forward. But I just want to make the point that it's something that we're all concerned about and continue to press to please, let's try to address that so that we can feel like or allow people to feel like they've gotten adequate notice and had the ability to respond and have the time to prepare to respond. I think my other concern, and I fully understand that there's, continuous pressure on the perimeter of neighborhoods for commercial enterprise to come in and encroach. And I think the concern is how do you limit that? How do you stop it from penetrating further and devaluing the property within the neighborhood? And I feel like, I hope that is the biggest cause of concern for everyone who's expressed their opposition to this special use. I guess maybe this is more of a question for John and Brandon, but it's my understanding that special use permits or authorization can basically have whatever limitations we decide to put on it, including that it could be restricted to a specific owner, although I think that's probably a difficult thing to administer. Is that accurate?
Well, to answer the first part, yes, you can place whatever conditions that you like and limitations on a special use, within reason, subject to the law. To my knowledge, the city has never limited a special use to a particular owner. I have worked in other cities where that is the case. As you alluded to, that can become problematic. I would not necessarily recommend limiting it to a particular owner, but if you wanted to further limit this particular or special use in terms of uses allowed or extra conditions that might help address concerns, that's really at your discretion.
If I may just comment on the notice issue. I mean, it's no secret there is a pending lawsuit out there, and I don't want to be very careful not to go into great depth on that because of that. But the notice issue has come up, and there is a provision in our ordinance that allows us to rehear cases, and we can't do it within a year from when it was first approved. So a big part of why we're bringing this back now is there were those notice concerns, is now that we've had time to see how this would work, and since there were those notice concerns out there, we've gone through this process, given all the notice that we're required to give, and give all these people the opportunity to come and speak on this. And as far as the permanent nature of the special use, I mean, this is something that's subject to revocation if they were in violation of something like that. And as you mentioned, placing restrictions or conditions on it, and one of the conditions in the last approval was that it would be subject to reinspection, and then we've done that here. So I just wanted to clarify that.
Okay. Brittany, you have any thoughts?
I'm on, okay. As far as, there's no doubt that this is definitely a tough case and it's going to be a difficult decision. I do understand, the neighbors' concerns on the commercial use, just in the sole fact that if this is permitted, then what could be next? But at the same point in time, and as far as how you actually, as Luke mentioned, limit commercial use in the neighborhood settings, especially a neighborhood like Santa Rita that does not have the restrictions that Southland, Bentwood, other neighborhoods would have. And I do understand, the gym is great, and I think that that's it seems like they're, again, with their faith base and all of that, in order to give the children something, somewhere to go and enjoy in a safe environment. So, I don't know, that's all I've got.
Okay. Joe?
Does anybody, so I remember this case. Most of us, well, three of us up here remember this case. Does anybody have, I hadn't seen any proof that anyone's property values have gone down since this thing was approved the last time. I have a feeling we probably won't see that.
They've gone up.
I would imagine so, right? I mean, I would imagine they've gone up. So I think the appraisal value argument probably doesn't really hold much weight. I will ask this of staff. I know the answer. We all up here know the answer. If Texas Tumbleweeds tomorrow decided to go do something someplace else, could LifePoint Church hire a gymnastics coach and do the exact same thing in the exact same space starting Tuesday morning without even coming here?
Yes, well, with the special use approval, of course, they
Correct.
could. Even without the special use, if that's a function of the church.
Correct.
They could do that, yes.
Those are my only two comments.
Okay.
Terry, what are your thoughts?
So my thoughts are, I think it's a great opportunity for the children. It's a great opportunity for the church. I lived on the corner of West Washington and South Washington for 22 and a half years. I do live in Santa Rita now. The traffic where I lived is not any worse because of the gym as it is now. The property values have gone up, especially in the last year to 18 months. They've gone up exponentially in every area. I also feel that when we lived there, there was a daycare that was also done at the church, which was an allowed right that they have to do. And I see no reason in not approving the special use permit today.
Okay. The biggest hangup I have, and Luke has spoken to it, is it's really semantics when you talk about rezoning this property, whether it's a special use or we rezone it to commercial. What we're doing, what the city is asking us to do, is to approve a variety of uses that are commercial by nature. So the problem I have is that this approval runs with the land. It's not specific to the property owner. It's not specific to the church. And so at some point down the road, the church may not be there. The church could sell. And that is the slippery slope that I feel that we're on, is if that property sells, if LifePoint for some reason goes on to bigger and better things, if a portion of the property were to burn to the ground, and they sold a portion of it, they have these rights convey with that land when they sell it. And so to me, the separation of the church and what they're trying to achieve with the property that they have, and the property and what's allowed to be done on that property are separate. And so my hang-up is allowing a commercial use to run with the land. I don't think that it's good for our neighborhood. I think it speaks to an erosion of our boundaries, as Luke kind of alluded to. man, I would hate to see that. I'd hate to see the church leave and have this zoning allowed on it and fear what could go in if the church were to sell their property. So that is the overwhelming objection that I have to this case. So the other thing that we haven't addressed is that we have two members that are not here. And I don't know, I would like for us to discuss whether we want to make a decision on this without them present, given the time that's passed and kind of where we are.
I think I was just going to make a comment on your comments.
Okay.
So with the special use permit, it does remain with the land. I don't know that if a property is destroyed, that they have to rebuild it, and I don't know that would still stay with the property.
The zoning would stay with it regardless.
The special use, I think,
Absolutely.
may fall out.
They'd be allowed to put whatever they wanted to on that land, wouldn't they? I mean, it's a church. I guess there'd be limitations.
Churches are allowed by right to build in any residential area.
Correct.
But the property is zoned RS1.
It is, but all of
RS2.
these uses are allowed. An
special
indoor
use.
multi-use recreational facility, a daycare, a
But you're
community
confused.
outreach,
Correct.
community services,
Correct. But you're
educational
also-
programs.
You're also stating that it is commercial zoning, which these are allowed by right
I'm
to
saying
the
that-
church, and we're having a special use permit. But we also need to remember that there are 55 other businesses at least in Santa Rita that have special use permits, or not just businesses, but there are at least 55 special use permits actively used today in Santa Rita. This is not anything new.
Okay.
Why could the special use not be restricted to multi-use youth recreational facility or daycare, period?
So say again,
I'll just
I'm
answer
sorry.
that from a procedural question. Yes, as I mentioned earlier, you can limit this. You could limit it specifically to a gymnastics facility if you wanted to. And then if the church wanted to do any other of these things, they would have to come back for an amendment to this.
Or any other owner, if it's not the church.
Yes, I believe you could limit it to the present owner, and then a new owner would have to come back for a reapproval.
Well, I think what I was saying is if you restricted it to use as a gym, even if the church sold or parceled off this section and sold it to the gym, they'd still have to come back and get a special use permit. Or if they were to use it for anything other than youth gymnastics, if we worded it that way. Does that make sense?
Yes, you could limit it. Again, you have fairly broad discretion of how you would limit this. We've limited size of operations, size of building. You could limit to the number of students at the gymnastics facility if you wanted to ensure that they didn't, if the church burned down, they didn't build a gym 10 times larger. So
I'm serious, guys. Stuff like this happens. We could have a daycare specific structure built where the gym is today if the gym were to, God forbid, burn to the ground. We don't know what could go on the land, and we have all of these uses that are allowed by what the city's proposing for this case. I really think it's a problem personally. So.
And I think, John, so let's just say, playing devil's advocate, the church decided at one point they needed more funds than what the gymnastics center was bringing in. So they go and they sell that portion of the land. It already had a special use permit attached to that part of the gym, right? So then technically would the gymnastics facility, if they were to purchase that, have to come back and get it rezoned commercial? Or are they automatically still granted to operate since they had the special use permit? And it's, again, attached to the land, not the owner.
yeah, they would still be allowed to operate. This special use is not specific to the church as the owner. It's not specific to Texas Tumbleweeds. If Texas Tumbleweeds bought the gym separately from the church, then they would be a business owning the property, but would still be limited to the RS1 zoning and whatever additional things you allow through this special use permit.
So then it technically would be commercial at that point.
Exactly, and that's really kind of the point that I'm trying to make. This is really broad. They could sell off a small portion of the land to someone that built any of these facilities, any of these uses, and it would be allowed. And that's my objection to this case, personally. So,
And I guess I
do we
would-
want to move forward and have a vote, or do
We
do
have
we
a
want the
majority,
other,
why can't
do
we
we want
move
the other
forward?
members present when we do this? Does anyone have other thoughts that they'd like to share before we vote, if we're going to do that? Does anyone want to make a motion?
I want to make a motion, and we do have a quorum. I would like to make a motion to approve as requested.
Okay? We have a motion. Does anyone wish to second that motion? Okay, that motion has failed. Does
I'll
anyone
make a
wish to
motion.
make a motion?
I'll make a motion. I'm going to make a motion that we deny the request. I'm not saying that in the future, if we can figure out a better way to present this case, but I think as it stands right now, I'm going to make a motion to deny.
Okay?
I'll
Mr.
second that
Chairman,
motion.
can I just, and I'm sorry I'm doing it right now, but if you do deny it, I'd like the board to consider a couple of findings with that denial.
Okay, why don't we do it after we deny it?
Okay?
Please.
Well,
We have a
before you
motion
take the
and a
vote,
second on the
Before you
floor.
take the vote.
We already,
We have a motion and a second on the floor.
There is a concern that a recommendation to deny without making some specific findings would not be appropriate, that you all, in order to deny it, based on some of the concerns raised by the owner, particularly the religious land use objections, it could be problematic if you do not make certain findings that I think Brandon can address what those findings need to be.
is this because there's a pending lawsuit? Is that why?
No, it's not.
It's federal law.
So Mr. Gaines, he discussed the federal law RLUIPA. There's also a Texas law that governs that, Civil Practice and Remedies Code, Chapter 110. And I'll read that out here. Subject to subsection B, a government agency may not substantially burden a person's free exercise of religion. And then subsection B goes on to say, subsection A does not apply if the government agency demonstrates that the application of the burden to the person is in furtherance of a compelling government interest. So compelling government interests are things like health, safety, welfare. Cases have also found preserving the nature of a residential district, but that's a finding that you would need to make to comply with this. Also that it's the least restrictive means of furthering that compelling government interest. So if you're able to place restrictions on it, like the conditions of a special use, if you can do that in a way to preserve that compelling government interest, then you do that before just flat out saying they can't do it. So I'd like you to consider that, have some discussion on it.
Okay, we have a motion and a second on the floor. I'd like to take a vote. So all in favor to deny, please say aye and show of hands.
Aye.
Aye,
Aye.
okay. And opposed to the denial?
Aye.
Okay, now, do we need to add to that? I don't
You can't add
understand.
anything. You've already voted.
We've taken action.
Okay,
Taking action.
all right. We'll move on.
I'd recommend we take maybe a 5-minute break to let the room clear out and.
Everybody hear me? I'm going to continue the meeting. So we're going back to the regular agenda items, subdivision plats. The Planning Commission has final authority for approval. Appeals may be directed to the City Council. I'm going to bring down the case that was on the consent agenda. Arden Estates, Section 4, request for approval of a final plat of Arden Estates, Section 4 being 12.925 acres out of Lot 1, Block 3, second replat of Block E, Section 3, Arden Acres, generally located southwest of the intersection of Arden Road and Northwest Drive.
Mr. Chairman, the applicant's representative is here, and he has requested that it be removed from the consent calendar. So, Russell, if you want to address your issues.
So I'm going to open this up for public comment. Mr. Gully, if you'd like to speak, come on up.
Thank you. Good morning. Russell with SKG Engineering. I just wanted to kind of highlight a few things and talk about them and see if we can kind of have them deferred. Much to do with the sidewalks, and then if we want to look at the conditions of approval. It talks about Arden Estates Drive doing plans for those. Arden Estates Drive is actually not included in section 4. It appears to be because it's kind of the way we plat around it, but it was actually platted and will be developed out as part of section 1. So the hope and expectation, and I don't know exactly how it'll time out. We're both working on both the single-family residential to the south that would really put into section 1 in this street first, but then they're also working on kind of the development of these two parcels where this one would go. So really we would ask that item 5 kind of be stricken or revised, kind of recognizing that it was approved to be installed as part of section 1. And then on the sidewalks, we'd like to have those deferred to the building permitting phase or future phase of development. For those, it appears, and the route they're going right now is looking at putting a multifamily project in up there. And so with that, the city will have the opportunity and you know, we'll be reviewing. I'm presuming it's probably be large enough that there'll be an urban design review. So the sidewalks will be installed. So we just would request that the sidewalks could be deferred to the building permitting stage as well. And we'd really be happy to answer any questions.
Okay, so let's go to this item 5. Prior to plat recordation, prepare and submit plans for approval illustrating the required construction of Arden Estates Drive, meeting all the requirements for urban local roadway. You want to strike that, is that correct?
Yes, or append to that something that would say, unless it's previously built and approved as part of section 1.
I think that'd be the better way to go, because just because we call it number 4, once it's an approved final plat, they could theoretically do that one first if they wanted to.
Right.
So leaving it in, but with some language that says unless already constructed as part of a previous phase, something like that. We'd be comfortable with that.
So.
And we're also comfortable, by the way, with the request to defer the sidewalks.
Okay.
To the construction.
Would you be able to put number 5 on the screen so we can see it?
Since this was a consent item, we actually didn't prepare a presentation, so we don't have those able to pull up.
I can show you the copy I've got, Terry, if that would help.
Okay.
And John, could you recommend how you advise changing item 5?
I just think where it says prior to plat recordation, prepare and submit plans for approval illustrating the required construction of Arden Estates Drive, comma, meeting the requirements of an urban local roadway, maybe comma, unless already completed as part of a previous phase of the development.
Are you good with that?
Yes, sir.
Mr. Gully?
Yes, sir.
Okay. Does everyone understand what we're being asked to do? Are the sidewalks an item on here? Russell?
Item 7.
Item 7.
Yes, sir. And then on item 6, this was kind of a fire department comment, and I spoke to Brenna about this. And I don't know that it's a big deal. I think we probably have some flexibility. And I commented to her that plat approvals, they get filed at the courthouse and they're pretty much perpetual. And this just says, it references a specific 2015 IFC. So in 10 or 20 years, someone could pull this plat out and the city's on now 2021 or whatever version of the I-codes. But the plat says 2015, so.
Wouldn't that be to your benefit?
It would be, so
I'm just saying.
It would or could be, so we're not opposed to it, but it just may be something you want to look at on how we word that in the future.
if we don't reference it, then the current fire code could be in play.
Absolutely.
So,
Forever.
yeah, so,
And we're okay with that, but.
okay, so leave item 6 like it is.
We're happy with that, yes, sir.
So,
I will say that I think regardless of your conditions on a plat,
yes,
the fire code, the then current fire code is going to apply when they seek building permits anyway.
I would hope so.
okay, so prepare and submit a sidewalk plan for approval illustrating the proposed installation of sidewalks on the south side of Arden Road. If placement of sidewalks is not feasible within the public right-of-way, easement shall be provided and illustrated on the plat. All you want there is to defer to the building permit phase. All right. Does anyone have a motion that they'd like to make?
And you can make the motion to approve as discussed without having to reiterate all of those changes.
Okay, so item,
moved.
I should jump on that.
so item 5 being, unless the road was constructed in a prior, unless the road has already been constructed, I think is something like that is what you were saying?
Yeah, something like that. We can go back to the minutes if we need to get the exact wording.
Okay, and item 7 is to defer the sidewalk construction to the permitting phase. Okay, anyone wish to make a motion?
I thought I had one on the floor.
Second, he does.
Okay,
I had one, yeah.
perfect. We have a motion and a second. All in favor, say aye.
Aye.
Aye. Opposed? So 5-0. All right, first replat of the north 105 feet of Lot 1, Block 5, Shepherd's Addition. Request for approval of a replat, or a first replat of the north 105 feet of Lot 1, Block 5, Shepherd's Addition being .12 acres located at 1231 Coke Street. Variances from Chapter 10.3A2 of the Land Development Subdivision Ordinance to maintain a paving width of 36 feet with curb and gutter in lieu of the required 40 feet or 36 feet with a 4-foot sidewalk with curb and gutter for North Irene Street and Coke Streets, urban local streets.
Thank you, Mr. Chairman. Sherry Bailey, Principal Planner. You have before you Shepherd's Addition. It's the first replat of the north 105 feet of Lot 1, Block 5, as was indicated. This is a final plat for just about 121 percentage of an acre. It's at 1231 Coke Street. It is in a single-family residential RS1 district. The future land use for that area is neighborhood. It's in District 3, Harry Thomas's district, and it is the Fort Concho East neighborhood. The existing streets on both Coke and Irene are 36 feet of pavement. They do have curb and gutter. And so a variance has been requested for both of those streets. Engineering and planning staff does support that variance. Variances have been granted for both Coke and Irene in the recent past for exactly that same reason. And we are recommending approval of this plat with 4 conditions of approval, and one of those conditions I want to talk with you about for just a moment. But the conditions are the tax certification, a variance for both Coke and Irene, and the last condition of approval is a garage 1-hour wall if the building remains. When this was replatted, and you can see on the plat with buildings, the reason that it was replatted, it's a parcel piece that the person has owned for a number of years. He wanted to get a building permit at that time. We discussed with him the fact that in order to do that, he would have to plat the piece of property. He platted exactly what he owned, which would allow then the second half of that lot to also be combined with the second half of both lots 1 and lot 2 to also be a buildable lot. But in doing so, the line had been drawn where it actually occurred in the parcel on the piece of property that is the garage. The owner is either going to remodel that garage when he remodels the house, or he's going to remove it. But we've added that condition to cover that. With that, are there any questions?
Anyone have questions for the staff? Thank you, Sherry. I open it up for public comment.
Good morning, Russell with SKG. We would ask your approval of the 2 variances as requested and approved by staff, and then would maybe ask for a little clarification, I guess, on the firewall issue, kind of the timing, the chicken and egg issue here, if you will, with being able to record the plat and being able to get a building permit and remodel the garage. Is there a way that item 4 could be deferred, if you will, to the building permitting side of things as well?
I think staff would recommend that we defer that into the building permit stage. We know that that's going to happen and happen fairly quickly.
Okay. Anyone else wish to speak on this case? I'm going to close public comment. Anyone have thoughts or wish to make a motion?
I'll move to approve with the deferment.
All right, we have a motion and a second to approve, deferring the garage requirements for a 1-hour wall to the permitting phase, building permitting phase. All in favor, say aye.
Aye.
Aye. Opposed? 5-0. Item B, first replat of Lot 1 and Lot 2, Block 1, Reese Albert subdivision, and Lot 1, Block G, Sunnyside Edition. This item has been withdrawn by the applicant. So we go to the next page. Related comprehensive plan amendment and rezoning. City Council has final authority for approval of comprehensive plan amendments and rezonings. 333, 404, and 412 Pressler Street. CP 21-03 is the typo in the minutes or the agenda for 04. 404 and 412 Pressler Street. Request for an amendment to the City of San Angelo Comprehensive Plan, changing certain lands from neighborhood to the commercial future land use on the subject property located at 404 and 412 Pressler Street. Presser Street. How do you say that?
Prizer.
Sorry, Prizer. I don't know. Prizer.
We were taking bets to see
I
how
won't
you
make that.
do pronounce
I won't make
that.
that mistake again.
Thank you, Mr. Chairman. As you indicated, you do have before you the comprehensive plan amendment and a rezoning request. This piece of property is presently being used as a youth facility, residential facility, and an office. The present owner of the property has made an arrangement with the alcohol, drug, and I knew I was going to get that wrong.
ATF.
Pardon?
Is it ATF? Okay.
Yeah,
Drug Abuse Council.
Alcohol and Drug Abuse Council, but the adolescent residential substance. They want to do the same thing, but they want to do it for both male and female. In this case, when we sent it out to the surrounding property owners, we did clarify what was being asked just so that they were aware of it. And this is in District 3, Mr. Thomas's district, and the neighborhood is Fort Concho East. We did have some calls on this piece of property. But they were asking for clarification more than anything else, and I did not receive anything that indicated to me that anybody was concerned about it. The biggest concern was that it would continue being a facility for children of need. So before you is the future land use and current zoning. Future land use on the left. We have the 4 lots where there is a 1 residential facility and the office, which is in the neighborhood future land use and therefore needed an amendment. And then all of the pieces of property are zoned RM1, and staff had suggested that it go to commercial office. The reason for the change to commercial office is that 1 block north, that is what occurred on the piece of property up there for the same group. It has worked well because that's a very restrictive piece of property and zoning. We sent out 36 notices. I received 1 in favor, and again, no opposition to it at all, just a concern that it was going to go away. In looking at the rationale, we felt that the commercial office is a reasonable use, and in suggesting that because it is so close to the downtown area, as you're well aware, and there's commercial uses all along that area. But it's still residential, and the RM1 has demonstrated that, in that there are 2 apartment complexes that are very close, as well as some smaller residential apartments. So it is both consistent with the comprehensive plan and with the zoning ordinance, and definitely compatible with the surrounding area. There is a slow change in the area to more commercial uses, and I think that's why a lot of the property owners that called were concerned that this use was going to go away. And so we tried to make them more comfortable with the fact that it was going to stay. We do not anticipate that there will be any effect on the natural environment because there's essentially going to be no change. And again, the drug and alcohol abuse group that is going to take over the facility is going to continue that use and to continue the use as an office. The development patterns are slowly changing in that area. Everyone is aware of that, but this particular use and comprehensive plan change is not going to affect that negatively. So staff is recommending approval of the request to approve a comprehensive plan amendment to change neighborhood to commercial for the property of 404 and 412. And then we are recommending approval of the rezoning from the low-rise residential to office commercial for the properties at 333, 404, and 412. Are there any questions?
Just to clarify that we're putting the same zoning on all of the lots?
Yes, we are.
Office, commercial?
Yes.
Okay. Or that's the request. Okay. Anyone have questions for the staff? All right, I'm going to open it up for public comment. If you wish to speak on this case, please come forward, state your name.
Good morning. I'm Stephen McLaughlin. I'm from the Board of Directors of the Concho Valley Home for Girls. Just to give you a brief overview of what's going on, I've been on the Board of Directors for somewhere around 18 years, and there's been a very definitive change in the state and CPS in terms of how they recommend and place children. And it is, the result of that is that our the number of girls that we have in residence at the girls' home and the number of children we're serving in the emergency shelter has dwindled to almost nothing. Sometimes we're down to 1 child. And so in looking at that and seeing that it was coming, the next thing is that the state has also put a requirement on us to get quite a bit of new, I don't remember what the word is, accreditation that's going to cost $30,000 to $40,000 for each of the operations. That's difficult for us to do. We're required to keep a staff ratio in case the kids come, and we can just see that in the long term, the mission is not going to remain viable for what we've been doing in the way we've been doing it. At the same time, we could see that there is still a great and growing need for residential treatment facilities for the young. There's not anything like that here or in the near vicinity. And as the board of directors, we thought this was the best way we could honor the mission of the girls' home and keep it moving forward was by partnering with ADAC. And that is the reason that we're asking for this. I couldn't speak to why it's a different zoning because essentially we're going to be serving the same kids. It's always been residential. It's just a change. I think that as far as the impact on the neighborhood itself, I think that our facilities are very stabilizing to the block and the property values. There are other properties on the block that could use some help. So I think our continued presence there is nothing but positive for the neighborhood. And I thank you for considering it. Thank you.
Thank you, Mr. McLaughlin. Anyone else wish to speak on this case? If you would, please come forward. All right, I'm going to close public comment. Anyone wish to make a motion or share thoughts?
I'll make a motion to approve as presented.
Okay, we have a motion and a second to approve as presented. All in favor, say aye. Aye. Opposed? 5-0. Z2107, 333, 404, 412 Prizer Street. Request for approval of rezoning from low-rise multifamily residential. It's the same case. Zoning district to office commercial zoning district being .880 acres at 404, 412, 331 Prizer Street. So we heard both of those cases at once. Rezonings. Z20-03 CBD expansion. Goodness. This is going to take a while, isn't it?
It's up to you guys. We think we've brought something back excluding most of the properties that were, that you all had concerns about. So I suppose it still could take a little while, but what we think we've presented is something scaled back significantly from what we had presented last month.
Is there anything, if we continue this to the next meeting, does that impact anybody that's trying to do something development-wise or otherwise?
No, I don't believe so.
There's actually one property owner that had requested to be included in this. It's not the entire facility, but it's a few properties for Palmer. If he doesn't get this, he's going to stay ML. He'll need a double frontage lot. He'll need a variance that could hold up his building permit. That's the only one I'm aware of.
From what I recall, too, he was under contract for the land across the way, and I
Yes.
don't know when his contract expires, so.
Do you guys want to hear this, or do you want to continue it to the next meeting?
Yeah, I don't want to hold anybody, I don't want to hold the citizen up.
Let's go.
You could, another option, you could push it to the end of the meeting. I hate to say that if people are waiting here, but, and see where you are on the other cases.
Let's do that.
Yeah, that's fine.
Yep.
We'll skip it for now. That's a great idea. Okay, go back to the agenda.
Sighs of relief out there.
Z2105, 2321 South Bryant Boulevard and 505 West Avenue T, a request for approval of a rezoning from the single-family residential zoning district to the neighborhood commercial zoning district, being .3 acres located at 2321 South Bryant Boulevard and 504 West Avenue T.
Thank you, Mr. Chairman. This piece of property, the one on the corner, has been a restaurant and a bakery since the early 70s. But it has been sitting vacant for a period of time, and the owner's grandson actually wants to restart it again as a restaurant. When staff was looking at the area, we went out and visited the area, that would have made the lot immediately to the west of this the only piece of property that was not CN in that area. And that piece of property has essentially been let run down because the property owner, one of the property owners had died, the other one was very elderly. So in contacting, we asked if they had a problem in rezoning, and nobody seemed to have a problem, so we included that piece of property. In the vision plan for this area, it is neighborhood center. It is in District 3, Mr. Thomas's district, and the neighborhood is Rio Vista. And as you can see, most of the zoning for the area is the neighborhood commercial CN zoning. It was just those two lots that were right there on the corner, and so we included those. And as you can see, the entire area is in neighborhood center on the comprehensive plan. This is a picture. On the left is the original building that was a bakery and then a restaurant, and the one on the right is essentially the abandoned piece of property that is included. We sent out 12 notices. We received none in favor and none in opposition. The rationale for the rezoning in this case is that the proposed zoning is intended to be commercial and neighborhood commercial, which serves the area, and it is very compatible with a comprehensive plan. The zoning itself backs up to neighborhood commercial and is a reasonable extension of that. And it's compatible with the surrounding area in that the restaurant itself has been there for a number of years and has just been vacant for a short period of time. It was used locally. And the residents that I talked to that were immediately across the street, the ones that had been there for quite a while, were definitely in favor of the restaurant coming back in. The intended use, as we've said, is indicative of the changing character. It's obviously on South Bryant, which is a very large street with a lot of traffic. The rezoning in this case is anticipated to have very little adverse impact. We believe this area of the city, in fact, is lacking social services or our local services for the neighborhoods, and believe that they will welcome it back again. And the existing development pattern shows that this is a transition area. We all know that from the comprehensive plan, and we believe that this is a nice balance for that adjacent residential area. And so staff is recommending approval of the rezoning from the single-family RS1 zoning district to the neighborhood commercial zoning district. Are there any questions?
Yeah, sorry.
No, go right ahead.
I mean, looking at the pictures, clearly it's a commercial building. You mentioned that it was served as a bakery since the 1970s. Why is it currently zoned as residential?
It never had its zoning changed. The zoning was always RS1, and there was never an effort to rezone it. And then when it was vacant for a couple of years, then bringing it back to that original use meant that they had to rezone it.
So had they continued to operate their
They would have been
business
fine.
without interruption, we wouldn't be having this conversation.
Exactly.
Been grandfathers.
It would have been grandfathered in. Okay. Got it? Good? Thank you. We're going to open it up for public comment. If you wish to speak on this case, please come forward, state your name.
Hello, my name is Rachel Avila. This is my first time here ever. First of all, I guess y'all are showing the, property 2321 South Bryant Boulevard and that 504 West Avenue T, that house is burnt down. The picture y'all showed there is no longer existing. Back in the 1960s, my dad owned that property. Shortly thereafter, and he owns the block, the one you have listed is number 16 on that map. Okay. So he owned that property straight down. It is? I'm sorry. Sorry. I want to say back in maybe 1963, that's when they built the Bryant Boulevard Highway. And in 1965 is when he built the building there, which is the cinder block building. And when he did that, the county commissioners granted him a permanent commercial zoning.
Okay.
And when it was changed, I never knew there was a change. From there, it was Villarreal Auto Parts, Villarreal Grocery, La Popular Bakery, La Via Bakery, it was Julio's, a number of businesses. And the last one was West Texas, I guess, Floors. And I don't know where that change came in. You know, anytime you buy a house there, like I say, my son lives across from the highway, directly catty corner from the building. My brother lives in my mother's house, which is right, I guess, to the north of the building. They're all listed as commercial. You buy a house, this description is commercial zoning. So I don't know why it was changed to residential. We've paid property taxes for years as a commercial. And if it was down for a while is when we needed renovations. And with the COVID, you know,
Sure.
we weren't able to do much. But I would like to request that it be left permanent as a commercial as my father had left, you know. I'm sure there's papers we would have to dig out on archives where, I don't know if y'all recall Marvin Hans. He's the one that recorded all those documents.
Okay.
And well, I'm here because my stepson was charged $645 to try to rezone, of which it should have never been done. I mean, we've been paying property taxes for decades on
Right.
commercial zoning.
So to answer, could we go to the staff to get an answer on the zoning when the county's designated zoning? Does the county have zoning? I guess is the first question.
No, the county does not have zoning authority, so I'm not sure what the county commissioners might have approved. We would just need her to provide records if there was, but even so, if the county approved something, once it was annexed into the city's
Yes.
rules would apply.
And it
our
was
records-
annexed in as single family, is that
That's what our records show, yes.
what your
Yes.
records show? Okay.
Because it's not a residential, it's not a home.
No,
It's
and
not-
I understand
you can't live off of
the
it.
confusion.
That's not unusual for that area. It was largely zoned residential.
Right.
Businesses popped up historically, and as you mentioned, they're grandfathered and continue as businesses unless they shut down for more than a year. And at that point, they have to clean up the zoning. We've
Okay.
seen quite a few of these in this general area
Yes.
over the years.
Yes, we have.
And within the year, that was during the COVID pandemic, that's why those people left.
Right.
You know. But I guess I have to go back and dig, or bring out archive records from what this was settled back then to commercial zoning.
This would resolve it.
Yeah, I was going to say, I think the purpose of this case is to permanently approve it for commercial zoning.
Okay.
So you wouldn't have to do this again.
Okay, how
Ever.
would I guess, if we've been paying property taxes on commercial zoning for years.
Right.
What more proof is there than that?
Well, I think the distinction is the appraisal district assesses on the use of the property. So if the use is commercial, then it's assessed at commercial regardless of the zoning. So they don't really take into account the zoning of a property for tax purposes. It's the actual use.
Well, that's what I'm saying, that's been the use.
Right,
since
and
1960.
our records show that it has been used as commercial, but it's never been zoned commercial. It's always been zoned residential.
For as long as it's been part of the city, within the city limits, according to the city's records, it's been residential.
Okay,
But the use has been allowed because it was an operating business when it was annexed, and it's remained an operating business until last year. So, that's it.
Until last year?
It's been a couple of years, I believe.
A couple of
Yeah.
years, okay.
Right. But again, this will clear it up forever, and that's what we talked about.
Okay.
This will definitely clear it up forever.
Okay, who would I present these documents to?
You really wouldn't need to present any documents. If this gets approved, then you're done.
Then it stays that way?
Right.
Yes, ma'am.
Okay. All right.
All right.
I'm sorry, I just
No,
felt
you're-
bad for him spending 645 when the
I
pandemic
understand.
going on. And
I understand your
that was right.
frustration. Yes, ma'am.
Thank you.
All right, anyone else wish to speak on this case? All right, I'm going to close public comment. Anyone wish to make a motion?
Move to approve as presented.
Second.
Okay, we have a motion and a second to approve as presented. All in favor, say aye. Aye. Opposed? 5-0. Okay, Z2106, 4125 Dan Hanks Lane. A request for approval of a rezoning from the heavy commercial zoning district to the heavy manufacturing zoning district, being 7.353 acres, located at 4125 Dan Hanks Lane.
All right. Good morning, Planning Commissioners, Chair Jeff Fisher, Principal Planner. Our next case today is a zone change for 4125 Dan Hanks Lane. This property is located southeast of Cristobal Road and South Chadbourne. And the request is a rezoning from the heavy commercial CH to the heavy manufacturing MH zoning. It's in District 1, Tommy Hebert, in the Glenmore neighborhood, and it's on 7.353 acres. So as you can see, it's actually 3 properties. So this is the parent property, and then there's 2 portions here of platted lots. So the applicants talked to us if they do decide to expand back here, they'll need a replat. That does not affect the zoning at all today. So I'm going to go over this really quickly. Comprehensive plan's industrial, so it does support rezoning to an industrial category like MH if it meets all the criteria. And as mentioned, the current zoning is CH. So 10 notices were mailed out. We did not receive any in favor or in opposition. We had 1 comment sheet that was returned by property owner number 3, which I sent you in your packet. They were concerned mainly about drainage, so I'll be sending that to engineering just to see if they had any concerns about that. And that looks like more about drainage in the area and not about this specific property. So I would just say there's none in favor and none in opposition, and then an unrelated issue. This is north on Cristobal Road, and this is so they have the existing location directly to the west at 3820 Cristobal Road. That's where they're located now. They want to move to this facility to the east off of Dan Hanks to provide larger building area, more opportunities for them to have their business and not be confined to the smaller property. This is an area that's predominantly industrial. It's been industrial since 2009. So they're kind of right in the middle of a couple industrial properties on either side. Everything from oil field equipment, there's a windmill company, and some vehicle repair. So that's north on Dan Hanks Lane right now, and that's looking south. So this is the subject property right now. So there's already several buildings there. This is a chemical manufacturing facility, and they do some processing as well. So it's that chemical mixing part. Everything else would fit under CH. It's really industrial service, but that one part that's doing the mixing of the chemicals is what pushed it up into MH. Staff rationale, we are supporting the request for approval based on the following. It's compatible with plans and policies. It's located in an area, I measured it on GIS, it's about 1.5 square miles as you go further east of industry. Again, that's been there since the 2009 comprehensive plan, and the zoning has been there. Most of those areas were rezoned pre-2000. Some of the rezonings, including the one to the west where they're at now, was zoned from CH to MH, just like this one in 2010. So it's consistent with the zoning ordinance. There's lots of room for parking, and if they want to expand and add another building, they'll be able to do that. It's compatible with the surrounding area. There is, like I said, industrial and heavy commercial already in the vicinity, including that zone change immediately to the west. Change conditions, the previous use was an oil field company, and it's been remaining vacant. So this will provide some more industrial tax space to the city, hopefully create some jobs locally as well. No effects on the natural environment, no significant effects. They had provided some summary sheets, and they did a pre-development DRC meeting with staff. So they've shown that most of the odor, the noise, and the traffic should be very minimal if they're going to do this. Most of the chemicals will be done inside and will be contained, so there shouldn't be any outdoor uses other than just occasional trucks coming in. Community need, I just mentioned, and then development patterns. It's located on Dan Hanks Lane, which is all industrial. And then once they get out of Dan Hanks Lane, you've got the corner of Christoval and Chadburn, which are two arterial roads that can accommodate those larger trucks. So we don't have any issues with that. And we're recommending approval of the rezoning from the CH zoning district to the MH zoning district on 7.353 acres at Dan Hanks Lane. That concludes staff's presentation. Any questions or comments?
Any questions for the staff?
And I think the applicant's here if they want to speak, so I'm just going to move it back to the map so you guys can, in case there's any discussion on that.
All right, we're going to open it up for public comment. If you wish to speak on this case, please come forward, state your name.
Good morning. I'm Charlie Neal. I'm with SMC Global. As was mentioned, we occupy the property on Christoval Road, and the processing there that we would do at the new facility would be the same as we do there now. So I'm here to answer any questions if there are any.
Anyone have questions? Thank you, sir.
Thank you.
Appreciate it. All right, anyone else wish to speak on this case? We're going to close public comment. Anyone wish to make a motion or?
Make a motion to approve.
Okay.
Second.
We have a motion and a second to approve as presented. All in favor, say aye.
Aye.
Opposed? 5-0. Urban design reviews. The planning director has final authority for approval. Appeals may be directed to the planning commission. An appeal of an amendment to UDR 19-04, an appeal of the planning director's decision to partially deny an amendment to UDR 19-04, which approved new landscaping, internal sidewalks, and paint color changes, but denied a 6-foot-tall privacy fence built to the front property line, located at 5702 Melrose Avenue.
Thank you. John James, Director of Planning and Development Services. You can see the location there of this development on the map. It is zoned for commercial, and although it is in basically one of the major entrances into the Bluffs neighborhood. Here are a few pictures. As mentioned, we did approve. The process is when a development like this comes in that's over a certain size, they have to submit an urban design review, and that's where we look at things like fencing and building materials and colors and landscaping and all of those sorts of design and appearance kinds of things. And so as they were in construction, they ended up doing some things differently than what were in the plans that got approved. So they submitted a revision or an amendment to the original approval, which we approved the changes to buildings, landscaping, et cetera. And the fence really is the only issue that's before you today. It's really this fence on the picture to the left. You can see the apartment homes behind that fence. Those fences, I believe, are 4 foot. And so the fences separating the yards from these homes is a 4-foot fence, but as it gets to the street there, it becomes a 6-foot fence. That creates some issues, not the least of which is that the zoning ordinance does not allow 6-foot fences up at a front property line. It has to be reduced to 4 feet. A couple of other issues that it's typically sidewalk design has fences and walls separated from the edge of the sidewalk, just to give a little bit of, designers call it shy distance, but basically if you're walking or you're in a wheelchair or pushing a stroller, it's not comfortable to have a wall directly adjacent, and you kind of have to scoot over. In this case, the sidewalk is right on the curb, which also isn't allowed by our standard sidewalk construction. They constructed it against the curb instead of back away from the curb like is required. That was part of the approval, working with engineering. That ended up getting approved rather than make them tear out the sidewalk and move it back. Just a couple of other pictures. Some of the landscaping was not in when these pictures were taken, so there will be some additional landscaping, particularly in that picture to the right. to meet their landscaping approval. So basically what you're looking at is on Melrose, that fence that's along that sidewalk right up against the street. I don't think, Jeff, we didn't have a picture of that house that's down the street. I don't think you can see that. Let me go back here.
Hey, John, I need to get on record to
Oh, I'm sorry.
recuse myself. Sorry.
Yeah.
Should have been.
Oh, no problem.
Should've run
I
away.
completely forgot. I should have given you that opportunity.
Get out of here.
Thanks.
Thank you, sir. Mr. Urick has recused himself.
Well, I thought this had a pointer, maybe right there, yeah. Well, you have to, I'm sorry, I can't point on this screen. We can't touch the screen like we can in the other facility. But if you see like these houses right here, we don't have a picture of it, but that fence along that side is back about 10 feet.
Yeah.
And so, if you picture driving through the neighborhood, it's not the best aesthetics to have fences up close to the street anyway.
Right.
But in that case, it is back some distance. And so our concern is that creation of kind of a wall effect that's not the most attractive entrance into into the neighborhood. Again, that's the one picture on the left.
It seems like one of the big issues here, this is a good representation. So all of these houses that front on Melrose, the front of those buildings is inward facing into the property.
That's right.
And so they're trying to fence the backyards of these homes. Is that
Correct.
correct?
Now, that is correct. Now, I will point out, well, number one, that they designed it that way going in. And again,
Right.
their original design didn't even have a fence at all.
Right.
They decided to add these later. The other thing to remember about this is really, it's sort of a hybrid between single-family homes and an apartment complex. This is one large tract. It's not split up into individual properties. So really the way to look at this is an apartment complex where each apartment is its own separate unit.
Yes.
And so the design of that, if you think about it like that, it is a little bit different than a typical design where each home has its own very private backyard. As I mentioned, the fences separating 1 yard from the neighbor is only 4 feet as well. And so we think to be consistent, it should be a maximum of 4 feet. Again, I think this is on an upcoming slide, but they will have to go to the Zoning Board of Adjustment. Even if you approve the fence today, the Zoning Board of Adjustment will have to authorize a variance from the zoning ordinance because that particular type of fence, regardless of urban design reviews, a 6-foot fence is not allowed in a front yard under the zoning ordinance regardless.
Is a fence of any kind allowed in the front yard?
Yes, you can have a front
What's
yard
permitted?
fence if it's no taller than 4 feet.
Okay.
There are some unique circumstances like ranch and estate where if it's like an open fence, like a wrought iron fence, it can
Yes.
actually be taller.
Yes.
But then you have that see-through. It
Yeah.
doesn't create the barrier. I've already mentioned Melrose as a front yard. It also blocks the visibility of the approved landscaping. Part of the original design, and you can see on there, they planted some landscaping in those, what are effectively backyards of those homes, as part of the design element. But now with that fence, you can't see that landscaping. And so the aesthetic impact that it was supposed to have in terms of a streetscape just is no longer there with this tall of a fence. If they reduce it to 4 feet, there are some shrubs you still wouldn't be able to see, but then the trees that they've planted will be a little more visible. The fence is located in a utility easement. We don't specifically prohibit fences in utility easements, but they are often discouraged because if a utility company needs to come in there and dig up a line, they're going to remove that fence, and they're typically under no obligation to replace it. Now, the city or AAP or whoever often does replace fences, but they're under no obligation to. And so part of our recommendation is to move that fence out of that utility easement. That puts it about 10 feet back, similar to those other fences that I showed earlier. I already mentioned it doesn't provide that shy distance away from a sidewalk. Again, it's not compatible with their original plan. If they had come in with this plan initially, we could have gone some back and forth and worked out something. But because they just went out and built it without coming back for a revision, that created this issue. And so the reason I say that is while we don't want to penalize people in a case like that, we also don't want to reward them for having done it incorrectly per their plans and now ask you to approve it after the fact, if you wouldn't have approved it before the fact. And as I mentioned, they will require a ZBA adjustment. So even if this gets approved by you all, the zoning board will have to consider whether or not to allow a variance to our normal fence height in a front yard. So our recommendation is to deny the appeal of the planning director's decision on the 6-foot fence and approve an alternative that they submit a revised plan showing the fence reduced to 4 feet as is allowed in zoning, and then to relocate it 10 feet back outside that utility easement. Be happy to answer any questions.
So how large would the yard be then?
That's exactly what I was gonna ask. Can you go back to that site
Those are
plan?
not big yards to begin with.
Well, and again, these are typical of apartments where you
Right.
often have, I've lived in apartments where your backyard is maybe 10 feet.
Right.
And so that was the original design concept of this in the first place. Jeff, I don't know the measurements on there, but if they do move it back 10 feet, I think that leaves them another 15 feet, if I remember.
Yeah, it looks like it's approximately 25 feet to the end of that grass, maybe a little bit further. So they'll have about 15 feet of yard space.
Now, of course, the other option they would have is to just eliminate the fence per
Right.
their original design, which was intended to be more of an open concept, more like a typical apartment complex where there often is no separation between adjacent units.
Yeah, the issue I see is that the way they laid this site out, they put the back of all of those apartments to their prominent entrance into the property. So they're trying to screen those backyards for the residents.
Have the neighbors across Melrose said anything about the fence? Or,
I don't
Well,
believe
it's
we've heard.
the school,
heard from
right?
them.
well,
Part of
down
it's the
further,
school, but you can
there's
see
like
there
five
are
houses.
4 or 5 individual single-family home lots. I kind of skipped over that part of my slide, but that's part of our concern is there are single-family homes across the street, and that's their front yards. And what they see out their front door every day is part of our concern of what you're looking at. And again, the original design of this you'd be looking out across a grassed yard rather than a 6-foot privacy fence.
I wanted to just briefly address Commissioner Davis's comment. Because an urban design review doesn't require public notice other than the agenda, the residents, unless they read the agenda on Friday, they wouldn't have known about this meeting. Okay.
And that's a good point that Jeff makes, that just keep that in mind. I don't know who's here to speak for or against it, but this did not get any notices to those other properties. So they don't take lack of opposition to mean that they might not have that concern.
Okay. Anyone else have questions for John or the staff? All right. I'll take public comment. I'd like to limit it to, 3 minutes. Are there a lot of folks speaking on this case? Is there anyone?
No, that's fine, just me.
Okay.
I'm the owner of the property.
Yes, sir.
My
Go
name's
right ahead.
Justin Harden, owner of one of the owners of Creek 27. A couple of things that, as field changes happen, and you get into the construction processes, things are going to be different than what you thought on paper. The fence, and I'll go through these quickly. In our original concept and design, and we went through the conditional use of this property back in 19, Jeff made a comment. One of his opening comments was the drive and the parking, private parking, was on the front of the units, making our yards in the back. So what happened was, we found ourselves in an opportunity. If we left it open, whoever's living there, their open space was along Melrose. It does kind of get busy with the school, with the neighborhood. So if they have kids, whatever, bicycles, access. So, kind of the thought process is we need a fence. It is their backyard, but we want to keep uniformity, keep a standard look. In the original UDR, they wanted the fence to match the bluffs. So along I guess that's the northwest and then the north side of the property, they wanted a 6-foot fence. And that's the exterior of the fence. The internal fences are all 4 foot. Right. Because we want to encourage, as we've talked before, and you guys know this, is, hey, we want to encourage the community, get out, see each other. So we wanted the same for those people along Melrose. But what we didn't want to get into was, they don't have the other people, they just have each other. So that's why the 4-foot fence is on the interior. But then you get into safety issues, and it was kind of where we were going with it. Like, what kind of liability are we looking at? A 4-foot tall fence. There is a 4-foot drop from the back of porch down to Melrose. So it kind of makes it an easy opportunity. And, I don't want to just make San Angelo into this dangerous place, but it's just that one time. San Angelo's not. But, one opportunity for somebody, a 6-foot fence may deter them. The original plans did have the 4-foot wide sidewalk back 2 foot, but there is zoning or code for residential in this city, because we are using residential code on the units and we're using commercial codes on the amenity center. So residential code in San Angelo states that and this kind of goes with the shy distance, if you don't have shy distance, they want you to widen. So we widened the sidewalk to 5 feet because we put that fence. And then so that's why, because we put it back a curb. So since we put it back a curb, since we were gonna have no shy distance, we made it 5 feet. Back a curb, engineer actually came out and he kind of encouraged it to my builder. I can have a discussion with those guys and will if you guys deny, but at the end of the day, he came out and said, hey, why don't you do 5 foot, push it back a curb? And he passed it and gave the permit for it. So it fell within the codes. It's open for interpretation, like John said, because there's no precedence here in San Angelo. Like, all the apartment complexes are the same as most cities, and having a property like this, you want to make sure that you're taking care of, the aesthetic, which I think the aesthetic's an opinion thing. I kind of happen to think it looks good. But the people that live there, like, what's the concern? Also you have to consider if there's an opaque fence or a 4-foot fence, people driving by, you got people in the morning drinking their coffee out in their robes, or they keep their bikes back there. Yeah. I mean, you could go either way with the aesthetic. Like, the traffic's in the morning and the evening, that's when people are gonna be out on their porch, they're gonna be hanging out, doing whatever they're doing. And does the people in the bluffs wanna go in and out? The school's far enough down, the fence isn't in front of it. The fence isn't directly across from the school at all. So, we felt it was necessary for the people that rented the units along Melrose. And then we also have to consider that we are a pet friendly. We don't deny any dogs. Let's say the big dog hops the 4-foot fence. It's been known to happen. It's running up and down the street. Got a school down there, kids walking home. I mean, there's a lot of what ifs, and it's all coming down to aesthetics. And that's an opinion. So that's
you have 4-foot fences inside the property?
Yes, sir. Yeah, here.
Are you 6 foot on either end?
I'm only 6 foot on the perimeter. I'm 6 foot here, and then as it comes up,
Right, but I'm talking about, like, in that entrance.
Right here.
Are you 6 foot right there on the side?
Sir. And then just right here, and just right here. Everything else is 4-foot fence.
Okay. All right.
So if you will, there's a 4-foot fence going in between.
Yeah, between them.
Yeah.
What about on the back side over here?
Right here?
Yes.
This is a retaining wall, and we built it up, so like it's 4 foot here, 5 foot here, so we built the fence up to be 6.
Okay.
Because that separates the property.
Yeah.
Mr. Harden?
Yes, sir.
I think I included it on here. If you go one forward or one back, it's the site plan that has the fences on it.
Oh, I don't.
Mr. James will show.
That
Yeah,
one broke
okay.
There we go.
Thank you.
Okay.
Yeah.
Do you have any fencing on the north side?
Yeah, we're gonna fence the whole thing.
Yeah. Okay.
So I felt like this being a 6-foot fence maintained the integrity of the perimeter of the rest of the property.
I understand.
So the green is 4-foot fence and red is
Yes,
6
sir.
foot, is that right?
That's right.
Okay.
Okay.
Thanks, guys.
Thank you, Justin.
let me clarify one thing. There was some discussion, I mentioned sidewalk, he's mentioned sidewalk. That's not part of your decision. That's already been approved.
Right.
The change to the sidewalk. So just want to make sure you understood that.
So what are you asking us to do?
The question is, should he be allowed to amend his urban design review to have a 6-foot fence in that front yard?
Okay.
So just for clarification, the 6-foot fence is going to go around whatever, the north or the west, or the whole property will essentially have a 6-foot fence,
Yeah.
making it a community.
The only part in question is along Melrose.
Okay.
Correct.
The rest was already approved.
Okay.
But it's not you're not gated. You don't have
No, sir.
restricted access into the property.
No, sir.
Okay.
Yeah, so it is only the fencing along Melrose. The rest of the 6-foot fencing around the perimeter
Good.
is allowed and
So
approved.
who approved this? He said that he had a permit for it.
I think he was talking about the sidewalk. Now, there's some questions about that, but
Said
that's.
engineering approved the fence.
Engineering approved allowing the sidewalk adjacent to the curb instead of 2.5 feet back, which is what the standard city code requires.
Hi, I'm Mindy Davis. I live in the Bluffs, 6030 Westminster. I take Melrose home multiple times a day.
Yeah.
And I do love the look of this property, but for aesthetics, privacy, I do think it's important to keep that 6-foot fence there. The sidewalks were widened to accommodate the higher fences. The people across from Melrose, which I do not live across, but the people living across from Melrose, they don't want to step out their front door and see someone in their row smoking a cigarette or having their dog do their morning business while they're drinking coffee. Front yard, backyard, that's the issue here. This is those people, their only private space outside is this gated fence. And although there's 4 fences in between, the 6-foot from the road provides them extra privacy from traffic, sound, noise, the other people across the street, the school buses coming back and forth. And so they did not sign up to live in an apartment complex. They signed up to live in this particular facility, which included a yard with a fence that was private. So I do think it's important to keep that in mind. Again, I do love the this particular property because I think it brings a new dynamic to San Angelo, and I think it's great for our city. But I do believe also that it's important to give those people privacy as well as maintain the integrity, not only of that particular, the aesthetics of that particular location, but also the Bluffs in general. Us coming home every day, we don't want to see that either as we're driving down that road. So I do think that widening the sidewalk was a combination for that. So, thank you.
Thank you. Anyone else have public comment? All right, I'm going to close public comment. I understand the issue, I think, pretty clearly. Personally, if the fence was set back 10 feet and you could landscape that area a little bit, it would, I think, help a ton. But you got a guy that's built a fence right along the sidewalk. And so it poses a challenge.
So I don't see, honestly, any issue with it being 6 foot tall by any means. I think that, the privacy thing was definitely addressed. Also, I mean, if you think about it, if any of those people did have a dog that jumped a 4-foot fence, that dog's heading to the highway. You know, I mean, so like safety on that aspect. Plus, again, if there's dogs in the yard and it's a 4-foot fence and you've got kids walking home along that sidewalk, you just never know. I think that and I understand that originally those lots were plotted that they were supposed to be the front yard, but it's reversed now.
Yes.
So I don't see any issue with the height of the fence by any means, especially with the sidewalk being widened in order to take away the shadow, whatever that's called, so.
I don't know.
I
I live 3 blocks from there, and I'll tell you, I think those guys and girls did a fantastic job building that place. I think it looks great. I like the way the fence is. Look, first of all, if we wouldn't have even have mentioned having the 10-foot setback with the landscaping, then nobody would even have called it out, right? I don't think there's a single person that drives by that beautiful property and says, man, I wish there was some landscaping 10 feet back, right? I agree. I think it would look fantastic if it was, but I'm talking about where they are today. I think they did a bang-up job. Again, I live right there. I walked through the property yesterday. I say walked, I golf carted the property yesterday to see the inside for the first time. It looks fantastic. I think they did a great job. And I have zero problem with where it is today. I'm really proud of that neighborhood, and I'm proud of what they did there.
Yeah.
And I don't know them, by the way, but they did a great job.
I think the other aspect too is just, we work with a lot of builders in real estate, and the cost of material, labor, everything has tripled, almost quadrupled, that I don't know if that's a fair expectation to put it back on the property owner to move that fence or tear it down and lower it, especially since the rest of the perimeter is gonna be 6 feet.
Yeah. I think part of the issue, or the main issue that I see, is that it wasn't done per protocol.
Right.
Which that's why we're looking at it now.
That's why we're talking
anyway.
about it.
I get it.
So,
If they'd come in and talked to the staff about it ahead of time,
Yes.
we wouldn't be having this conversation.
correct.
Yeah.
Instead of just doing it. And also,
I've seen worse mistakes made, though.
yeah, yes,
Seen worse mistakes made.
yes.
Well, that fence isn't going anywhere if we approve it as it is. So this is our only chance as a community to make a change if landscaping matters, and getting a few trees or shrubs in that front yard space ahead of the fence to soften it, I think would make a difference. But I understand the cost aspect, and it's on one hand, it's not fair, but on the other, it makes sense that they would have come into the city before they put that fence in, especially considering the expense.
Yeah.
No, you're
So,
right.
all right, anyone want to make a motion?
Yeah, so I want to, I'm going to move to approve it. I'm going to approve it as it is.
So the 6 foot
Yeah,
next to the sidewalk?
yeah. I'm going to approve it as the customer is asking.
Okay. I'll second that.
Okay. We have a motion and a second to approve. Brittany. All in favor, say aye.
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 Opposed?
Aye.
You're welcome, John.
So it fails by a vote of 2 to 2. It takes 3 votes to approve.
Oh, okay. All right, conditional uses. Planning Commission has final authority for approval. Appeals may be directed to the City Council. CU 2107, 2458 Fisherman's Road. Request for approval of a renewal of a conditional use for a short-term rental in a single-family zoning district located at 2458 Fisherman's Road.
Okay. Thank you, Mr. Chairman. I'd like to make one clarification. Although the conditional use section where this ordinance resides, dealing with short-term rentals and bed and breakfast, is immediately adjacent, this is actually a renewal of an existing bed and breakfast facility, and it's her second renewal. As soon as the ordinance was adopted, she received her first bed and breakfast. She came back 2 years ago and had had a renewal granted at that time, and she's now here asking for her second renewal. She's consistently used it as a bed and breakfast and has a lot of people who are returning for that. She lives in the home. As you're aware, that's part of the bed and breakfast requirement. It's in District 1, Tommy Hubert's district, and in the Nasworthy neighborhood. It's a neighborhood area on the comprehensive plan. It's a neighborhood, single-family residential area. She's very familiar with all of her neighbors, and they are with her. This is a picture of the front of the property, and as you see the property as you drive by, there's no indication, of course, that it is a bed and breakfast if you didn't know that it was. We sent out 7 notices, and we received 1 in favor, which was a very glowing recommendation, and 1 opposed. And the person who wrote the one that is opposed, I went back and talked to them. Their concern is that the people who come there don't have good water usage understanding of safety. And the 2 situations that they referenced in their letter were both because they were out without life jackets. And their recommendation was that if in fact, or I talked to the neighbor actually immediately adjacent, and their recommendation was to put safety information in the bed and breakfast, just normal information reminding people to wear safety vests, that kind of thing. There have been no impacts in talking with the surrounding property owners about this being a bed and breakfast. It looks just like any other residence. It always has either 1 or 2 extra cars, and that's basically it. It's consistent with the zoning ordinance. She has maintained the bed and breakfast. It's a residential area with lake traffic. The past history of this bed and breakfast shows that the applicant maintains the rental and does not impact the neighborhood. We're not anticipating any effects on the natural environment. And staff does believe that there's obviously a demonstrated need out on the lake. We get requests constantly, and particularly for short-term rentals, and because of the requirement of the 500 feet, many of those aren't able to be granted. This bed and breakfast has shown that it meets the needs and is constantly being rented. And there are no changes anticipated because this is an existing bed and breakfast. Staff is recommending renewal of the conditional use for the bed and breakfast at 2458 Fisherman's Road with 2 conditions of approval. That's maintaining the off-street parking on the premises and everything else inconsistent with the manner as the ordinance dictates. And operation of the bed and breakfast also needs to be consistent with section 406. Again, she has done that, and that's why staff is recommending approval. In checking with the police department, the fire department, the building department, and code enforcement, she has had no referrals.
Okay. Thank you, Sherry.
Anyone
have questions for Sherry? All right, we're going to open it up for public comment. If you wish to speak on this case, please come forward, state your name. I'm going to close public comment.
Make a motion to approve as presented.
Second.
We have a motion and a second. All in favor, say aye.
Aye.
Opposed? 5-0. CU 2108, 4630 Permian Drive. Request for approval of conditional use for telecommunications facilities within general commercial zoning district for a property located at 4630 Permian Drive.
As you indicated, this is a conditional use for a 150-foot telecommunication tower on the lot that's highlighted up there. The general commercial is the zoning for that area. It is in District 1, Tommy Hebert's district, and it's in the Rio Vista neighborhood. When we get to the zoning map, you can see that it's almost entirely heavy commercial around just this area that is general commercial. There are no other towers in that immediate area, and so staff was able to discern that it met the criteria that we used to review. The tower is intended to be 140 foot from the front property line, 35 foot from each side, and 35 foot from the rear, which meets all of the requirements. There's a residential or motel just immediately adjacent. She did call, talk to me about it. After we went through there, she indicated that she did not have a problem with it. 11 notices were mailed out. We received one in favor, and that was the lady with the motel who called, and none in opposition. Again, we do not anticipate that there are going to be any impacts from the telecommunication tower. The CU conditional use is consistent with the ordinance requirements for tower placement. They're meeting all of those and the separation from residential zoning. This is generally a commercial area or a heavy commercial area, and the tower fits into that area. Effect on the natural environment is not anticipated. The staff believes that there is a demonstrated need in the community for telecommunications facilities. We all know that, and that there's always a change and upgrade, and in this case, they are putting up a new tower that will have co-location. And development patterns, there are no changes anticipated in the area because it is a commercial area. We are recommending approval with 4 conditions of approval. The first being that this 150-foot tower be the only one in that general area of the site. Again, that it must comply with the standards in section 426, and it does. We are asking that they indicate latitude and longitude coordinates so that we can map it on the GIS mapping. And 4, that the tower and equipment, including the platform and pad, shall be maintained within the triangle identified on the site plan, and they've indicated that it's going to be. Are there any questions?
No?
Okay.
We're going to open it up for public comment.
My name is Tony Cuellar, and I'm the owner of the property. I'm here to, if you had any questions, I can answer them.
Anyone have questions for Mr.
No.
Cuellar?
No.
Thank you, sir.
Thank you.
Anyone else wish to speak on this case? I'm going to close public comment. Anyone wish to make a motion?
Make a motion to approve as presented.
We have a motion to approve as presented. All in favor say aye.
Aye.
Opposed? 5-0. Right-of-way abandonment. City Council has final authority for approval of right-of-way abandonments. Alley right-of-way abandonment, 500 block of East 41st Street. A request for approval of the abandonment of a 2,250 square foot alley on the south side of East 41st Street between Oaklawn Street and Bowie Street.
Good afternoon, Commissioners, and Terry Strabling. I'm Cooper Carroll, the planning intern. So a little background on this case. The property owner, who is also the applicant, owns property on both sides, and they wanted to build a carport, so that's what initially triggered this.
Okay.
So as you stated earlier, this is on the 500 block of East 41st Street. They are requesting to abandon the entire alley. It's at District 2, Tom Thompson, in the Lakeview neighborhood. So the future land use is neighborhood, and the current use is single-family residential. This is the subject alley right here. Some rationale for approval. We don't see any negative effects. This is an unpaved alley, and there's no rear garages or carports that connect to this. There's no city or private utilities in the alley. We circulated all private utility companies in the city, and none of them had any responses. We sent out 18 notifications. We heard nothing from the neighbors in the area, and closing this entire alley, not just part of it, will benefit all the owners, especially the applicant who applied. Here, this shows the 18 notices mailed out. There were 0 in favor, 0 in opposition. We recommend approval of the proposed abandonment and vacation of a 15-foot wide by 150-foot long, 0.052 acre public alley located on the 500 block of East 41st Street within the block of 58 of the Lakeview Edition, subject to 3 conditions of approval. The 3 conditions of approval are the payment of the assessment formula, recordation of quitclaim deeds, and a subdivision replat encompassing an abandoned alley portions into adjacent lots within 18 months. Okay. Do you all have any questions?
No.
Anyone have questions for the staff?
Nope.
Thank you. We're going to open it up for public comment. Anyone wish to speak on this case, please come forward, state your name.
Okay, on the comments below, where it says getting the plaque and all that, I know we have to get the plaque done. When do we do that?
I'm sorry, ma'am.
Within 18 months of the approval.
Ma'am?
Within 18 months of the approval, you would have to have the property replatted. Is that,
Sure, please.
So we changed that. I guess it didn't get passed on to this
Oh, okay.
draft. It's actually 36 months.
36 months.
So am I approved for my
No.
land or what?
Okay. You want to build a
I'm
carport?
confused.
Okay. Are you building a carport?
I'm trying to get the driveway and then I eventually want to put a carport on it. Yes.
Okay, so what we're doing is approving your right to purchase the land.
Okay.
I think, and correct me if I'm wrong, John, but she's going to have to pay for the land if she wants to build a carport. And-
Well,
and
yes,
record
yes
it.
and no. It's not technically a purchase.
Okay.
We have a fee formula.
right.
So it's based on the property value, but it's less than what you would buy the property for outright. But yes, it's an acquisition of sorts.
So when she leaves here today,
It goes to
does she
city
need to do
council.
anything?
Yes, she'll have to begin the process to replat that property. Well, it has to go to city council
Has to go to
first,
city
but once it's
council.
approved by city council, she would have to go work with a local surveyor engineer to replat the property to incorporate the abandoned alley into her adjacent property. Once that plat is filed, then all of it becomes her property. At that point, she could get building permits to construct a carport or other.
Okay, we're trying to get a hold to the people for the plaque, but they're not returning calls or anything.
The survey companies?
Right.
They're busy.
You could talk with, yeah, you could talk with our staff,
They could help?
and they could help with that.
Perfect.
So
Okay.
they're still gonna be in the loop?
I think we need to vote on it first, right?
Yeah, we're going to have to vote on this. So I'm going to close public comment. There's no one else speaking on this case. All right.
I'm going to make a motion to approve it as presented.
yeah,
Second.
Okay, we have a motion and a second to approve. All in favor, say aye.
Aye.
Opposed? 5-0. Okay, right-of-way alley abandonment. 500 block of East 44th Street. Request to approve an abandonment of 2,250 square feet of alley on the north side of East 44th Street between Oak Lawn and Bowie.
Yes, sir. So a little background on this one. The applicants, they have been taking care of the alleyway. They've been mowing it. They've talked to their neighbor to the west, and he had no issue with them acquiring this alley.
Okay.
So, as stated, this is located on the 500 block of East 44th Street. They are requesting to abandon this entire alley. This is in District 2, Tom Thompson of the Lakeview neighborhood. Future land use is neighborhood, and the current is single-family residential. This is a picture of the subject alley. So there is no negative effects that we see with traffic patterns. It's unpaved, and there's no rear garage or carports. There's no private utilities in the alley. There is, we talked to the city, there is a 6-foot sewer line within the alley, so they're going to require an unobstructed easement. We've had no responses from circulated residents to date, and this will benefit the property owner who's already taking and maintaining the alley. Staff is recommending approval of the proposed abandonment and the vacation of a 15-foot wide by 150-foot long 0.052 acre public alley located on the 500 block of East 44th Street within the Block 34 of Lakeview Edition, subject to 4 conditions of approval. That is the payment of the assessment formula, recordation of quitclaim deeds, subdivision replat encompassing the abandoned alley portions into adjacent lots within 36 months, and to provide an unobstructed 15-foot easement to the satisfaction of the city. Thank you. You all have any questions?
Any questions? Nope. All right. Thank you. Going to open it up for public comment. Anyone wishing to speak on this case, please come forward. All right, I'm going to close public comment, and anyone want to make a motion?
Move to approve.
Second.
We have a motion and a second to approve as presented. All in favor, say aye.
Aye.
Aye. Opposed? 5-0. Now back to the Z20-03 CBD expansion. It is 1219.
We discussed this briefly. You have a couple of options. One, Mr. Palmer had come in asking about a rezoning, and we said, hey, this CBD thing is going forward already. We can
Yes.
piggyback you onto that. Had he applied at the time he came in, he wouldn't have been on the agenda till next month anyway.
Okay.
So tabling this wouldn't necessarily delay him more than he would have been delayed otherwise. Another option, which we've not done, so it's a little iffy, but we could split this case into two pieces. You could approve just his properties, move it on to city council, and then we could bring back the rest of it next time.
I'm inclined to continue the whole thing, if you guys are.
Let's just finish it up.
Y'all want to go through this now?
Get on
Or
with
do you want
life.
to do it in the next meeting?
I want to finish it. Please. There's no reason to delay again.
Yeah, we're already here
Yeah,
at
we're here.
12:19. What's another 30
Did
minutes?
you order lunch? Getting a little hungry over here.
Okay.
And I think Jeff can make our
Tim
presentation
Hortons.
quick. Again, it's mostly what you saw last time.
Getting hangry.
We just,
I'll be completely honest, I am a little hungry. Past my lunch hour. I'll cut into my eating time.
so again, I think we can be pretty quick.
Let's go.
It's largely what you heard last time, but we subtracted out some of the areas of concern that you raised.
Okay.
So our recommendations to approve are going to stay the same. So instead of going over all that criteria, like John
Yes.
said, I'm just going to focus on the changes and we'll go quickly.
Okay.
So after further discussion with some of the Z2003, CBD Northwest. So this is the change. We decided to pull back because we were getting a lot of concerns from the industrial property owners that were zoned ML, not wanting to change to CBD. Their biggest concern, some of those uses, as we know from last month, would be outzoned without a conditional use. The second issue we looked at is 10% outdoor storage is the maximum in CBD. I found at least 3 or 4 properties in those ML zones that were probably going very close or could exceed 10% in the future. So what we did is we scaled back and basically we took out a few things. So we took out the 2 car dealerships and the hotel over here, because we believe that's getting really far out of downtown.
Yeah.
Plus, car dealerships are usually larger uses that don't really fit in downtown. So we took those 3 properties out, and then we scaled back. We took all the properties north of 3rd Street and west of Far Out, except we added Win Palmer's 2 properties here that he's got a building permit pending. And then east of Far, we're taking everything out north of 4th Street. This was the Salvation Army that was already out. So basically,
It's
nothing.
included already.
Correct.
Okay.
Correct. So nothing north of 3rd to Far Street except for Palmer's, and then nothing north of 4th. So that scales it down to 29 acres instead of, I can't remember what the acreage was, but from about 84 properties down to 53. So it's a significant change. We had one opposition, or I guess, shouldn't say opposition, they wanted to go to CBD. So there's one, I think it's the Masonic Hall in this area here, sorry, on 4th Street, that in this block. So they're actually 328 3rd Street. They wanted to go to CBD because they're zoned RM1, and I think they just wanted kind of higher and best use. It didn't change our position, but I did tell Mr. Davidson I would include this, I would note this in the presentation. This would just leave one property in, kind of in the middle of a block, and I'm not saying it's spot zoning, but it would look kind of weird. So we just think everything north of 3rd could stay. If they wanted that Masonic Hall, I think it's office, so it's still legal nonconforming. And then if they ever want to change that, I mean, we could always consider that at that time. There weren't any other issues. The opposition and the support hasn't changed since last time. So really, it's just the 2 Palmer properties that were added.
Okay.
And again, just to clarify, staff wouldn't have a problem adding that Masonic Lodge in since they want that change. We had just, when we talked about where to
Clear
scale it
lines.
back, a line across that street.
Clear
But
lines. Yep.
you could clearly add that back in based on their more recent comments if you desire to.
And it's
we
one,
wouldn't oppose that.
that's right. And it's one lot. It's three, I can give you the address when you vote. It's 328 West Third.
So let's go to Wynn's lots, or Mr. Palmer's lots. He wants to rezone them.
Yes.
Is that correct?
Yes, at this time, he does. He has a permit in for a warehouse.
Yeah, let me clarify, not all of their property. They had originally
The two
asked.
lots that he was under contract to purchase only?
Yes.
Okay.
So all of the rest of the property that they wanted out, they still want out, but those two they want to include.
Okay.
That's
what I thought. That's why I was asking.
Not included also.
Yeah, that's what I thought.
You're saying he came in.
He said, I think that's what he said last time, but after discussing the pros and cons, he's changed his mind now.
He wants in
In
on
fact,
the two lots.
he was willing to come in and actually apply for it, but we said, no, it's already going forward
So
here.
can we talk about that so that I understand what it being in CBD, what change occurs from that's more beneficial for I mean, his property is a good example. I feel like, we can look at it on the map and see exactly where it's at and how it'd be impacted. What's the difference between that and what it was zoned before?
Okay, so the current zoning is ML, so he wanted to he owns all of this already, these two lots at the bottom. He didn't want to touch this because he's already got industry, but he wanted to build a warehouse, which is allowed in CBD. It's not manufacturing, just warehousing and storage. The ML zoning right now requires two 25-foot front yard setbacks. So basically, CBD would allow him to go to 0, and he could fit his building over here. So he had an issue. He couldn't meet the setback on Far Street.
Yeah. He gets a larger footprint if he rezones it.
So his other buildings is staying ML originally
They're out.
Right.
Okay.
That's right.
Okay. Of the 53 properties that you've identified to rezone, have you spoken with the property owners? Where do we stand with notice to them? Is there a chance that we could have an owner that comes back and says, you did something without my knowledge or consent?
Yeah, and I think this is tough because we meet the state requirement. We sent the notices out. So there hasn't been any change other than the scaling back. So the only owner that had the concern that did reach out to me was representing the Masonic Hall, that one lot that wanted to go to CBD. All the owners that were objections were not including their properties anymore. So they were all those industrial owners that had submitted a notice saying we don't want to be in. We took those out.
So a lot of these blocks that are identified are single-family homes. Is that correct? Like 3rd Street,
right.
2nd Street, 1st Street? Isn't that a lot of that single-family?
That's right. I'm just going to quickly go to the zoning map so you can see. So that's correct. So even though some of that zoning is commercial, the orange is RM1 and the CG is the commercial, it's a mix. So it's a mix of retail, it's a mix of office and housing altogether.
But I would point out that none of those homes are zoned single-family residential.
Right.
So
I'm talking about the improvements that are there are single-family homes predominantly, right?
Many of them, yes, but
Okay.
to the extent that they would be non-conforming under the CBD, they would also be non-conforming under the
whatever
existing
it is
zoning.
they have now. I
Right.
understand.
It puts them in no worse situation.
Right. Okay. All right, anyone have questions?
Clear as mud.
Clear as mud, exactly.
So, can you put that map back on so we can look at both of those again, please, Jeff? The one that was, that one. Can you do them separately where they're not all, can you show me just April by itself for a minute and then show me May?
Don't think we have a slide that has April, the
Okay.
April map, big full screen, do we, Jeff?
No.
Okay. I was just, that was,
So basically, just if this helps a little bit with the pointer, these 3 properties are out
right?
in May. And then from Bryan over, north of 3rd Street is out.
Yep.
Palmer is in, there's just these 2. And then everything north of 4th Street is out. So all of this up here is out.
Yeah, all of that north of the railroad tracks and up on the Houston Heart, all that's out.
Is it ML zoned right now
Correct.
predominantly?
That's right.
Okay.
And we think this is probably a good compromise for now. It gets the properties that already have, from our research, most of those properties are already, the commercial ones would be legal in the CBD.
and the housing, so you'd have the 0-foot setbacks. It just allow a little more flexibility, and then leave those industrial owners that didn't want to be in out of it.
For the most part, the CBD zoning is more flexible and broader than the existing zoning for these properties, is it not?
Yes, in fact, I mean, really the only things you can't do are the really industrial uses and the outdoor storage. You can't have a whole lot that's just filled with storage. Those are really the two main differences.
Okay. So if someone has an existing industrial use with excessive outdoor storage, are they one of the 53 properties that's being rezoned? Are there any properties that are being rezoned that have big yards that are all of a sudden in non-compliance, or is it a legal non-conforming when it becomes rezoned? Are there any cases where that, okay, go ahead.
So these are the outliers, the nonconformities that are still in this CBD zoning. So the red circles are their uses that fall under industrial services. That includes a landscape contractor company here, an electrical contractor. So I think the landscaping here, it's hard to tell from standing from the street, but they might have, for example, more than 10% outdoor storage. This vehicle repair here, probably not. Most of their uses are, the vehicles themselves that are being repaired outside are not going to be considered outdoor storage. So I would say this one's going to be an issue. And then I think the roofing company definitely is over 10%, like their whole yard is covered. So I think Hartman Roofing and the landscaping, I would say those two are going to have issues with 10%.
Well, no, but remember, they're grandfathered.
I was going to say, so when we make this change, what happens to those guys?
They would be allowed to continue as is for as long as
they have an uninterrupted business.
Correct.
But, correct me if I'm wrong, but in the past meeting, if they wanted to add anything, like let's say Hartman needed more storage, then he is non-compliant.
Correct. They could not expand, but they could continue as is.
Has anyone talked to Hartman? Like, I feel like if somebody actually like understood that, I don't know if he would still want to be part of the CBD personally.
No, we haven't had discussions with them.
They received their notifications.
They did. And I think that was when we first reached out, it started with Ms. Bucher when she was here last year, and she had sent out the notices, and so we had kept out all those people that had objections at that time. And then we sent it out in April again, so based on that, we assumed that if they didn't have objections last year, it probably wouldn't change, but I understand Commissioner Davis's concerns also.
Now that we've reduced the number to this amount, I think, particularly with the roofing company, we could contact them between this meeting and city council. Our intent all along was to remove anyone who was opposed.
Right. Yeah.
So I think we could contact them, and if they do say they're opposed, staff would recommend withdrawing them prior to council.
I mean, I feel like a lot of the time those letters get lost, or maybe the receptionist opened it, didn't really know, and probably didn't get handed off. Like, that just worries me a little bit, just having them lumped in there if they really don't know what's happening for future growth.
Yeah.
So.
I share the same concerns with those properties that are non-conforming. But the only ones that fit in that box are the ones you've circled on this map, right?
That we're aware of from our ground research.
I would point out that I believe the roofing company and that property to the south, both are non-conforming in terms of buildings. So they have buildings that are too close to the street, the setbacks.
Yes.
So if those buildings burn down, they would not be able to reconstruct as is, but under the CBD zoning, they would. So there's definitely, from their perspective, pros and cons.
Trade-off of benefits.
Right.
Yeah, I understand. Okay. Anyone else have questions or wish to make a motion?
No?
How do you make it?
I'm like, I don't even know how to.
Luke's pondering it. Go ahead, Luke.
Yeah.
I mean, I think that the vision map that you presented this time versus last time is much better, but there are, again, those non-conforming properties that do worry me right now. Like, so I don't even know how to make a motion towards that.
I'm not sure that would, you would include that in a motion, but I can tell you that we will contact each of those, or at least the best of our ability. Sometimes they're hard to contact, but,
Yeah.
and if any of them are opposed, then we would change our
There you go.
recommendation as this
Sure.
goes to city council.
There you go.
Yeah.
I'll make a motion to approve as presented.
Second.
Okay, we have a motion and a second to approve as presented. All in favor, say aye.
Aye.
Aye. Opposed? 5-0.
Thank you all.
That wasn't bad.
Yeah, thanks, guys, and thank you for revamping that.
Director's
No, you're
report.
right, Brittany.
I just have two things. I want to mention Shelley Pascal is her last, well, technically her last day has already passed. She came back to us to help present the LifePoint item. She has received a promotion. She's now the stormwater manager over in Public Works.
Congratulations, Shelley.
So she's moving on, but we'll miss her. The only other thing, I don't know that we communicated this well to you guys, since this is our first in-person meeting, for a variety of reasons that I won't get into, decision was made that this will now be the home for almost all
permanent.
boards and commissions.
Okay. Oh, yeah.
So DHRC, Zoning Board, Planning Commission will all be meeting in this space. And so this isn't a temporary thing for today. A combination of COVID, but also waiting, you might notice all the new audio video equipment that we now have the ability to record this, post it on YouTube, live stream, all of that stuff we can now do in this facility. So basically all boards and commissions, with the exception of city council itself, will be in this meeting. If you have thoughts or comments on the layout, I think we're supposed to be getting some table skirts so that, you know.
Look, my only request is a slightly more comfortable chair.
Yeah.
I don't know about anyone else.
You can wear your.
If we're going to have 4-hour meetings.
Yeah, well, we'll try to avoid that.
Yeah. So obviously somebody got tired of changing the chairs out after every meeting and putting the leather chairs back.
I don't think that was one of the list of reasons, but that's all I have.
Request to order meetings in the future.
All right. On that note, future meeting agenda and announcements. The next regular meeting of the Planning Commission is tentatively scheduled to begin at 9 a.m. on Monday, June 21st. Adjournment.
Thank you.
Second.
All right, we have a motion and a second to adjourn. All in favor, say aye. Aye.
Bye.
12:37.